is passed, comma, learned counsel appearing for the appellant seeks a limited stay of the judgment in view of the appellant being a petrol pump and the running of the same being apprehended to be disrupted in view of the above judgment. Full stop. Accordingly, stay of operation of the above judgment is granted till Puja vacations are coming. So
8 weeks, Milord.
not 8 weeks. Till
Listing is
Supreme Court will be open.
Supreme Court is open.
Milord, listing will be typing listing
Till October 31, 2025. এটা
will
ঢুকিয়ে-
Milord,
আমি যে পর্যন্ত এর আগে বলেছি সব ঢুকবে, সন্ধ্যারানী ফোন দিয়ে সবকিছু এই পর্যন্ত ঢুকবে ওপরে। তারপর শুধু স্টেটা যেটা ও চাইলো এখন ইন্টারিম অর্ডার স্ট্যান্ডস ভেকেটেড
হ্যাঁ,
বলে দিলাম তো, ইন্টারিম অর্ডার স্ট্যান্ড ভেকেটেড পর্যন্ত সব সন্ধ্যারানী ফোনে সব উপরে ঢুকবে, জাজমেন্টের মধ্যে ঢুকে। নামটা সন্ধ্যারানী গুপ্তু আর গুপ্তু,
GOPTU, GOPTU.
GOPTU।
Milord, instead of 31st, give us first week of November because Milord, our court is reopening Milord.
No, our court does not have any effect on this. Supreme Court is open.
Till Milord, the first week Milord of November.
Thank you. Next.
My lord, before your lordship takes up this matter, this is from an interim order. The appeal is from an interim order, but the interim order has been extended further, and they have preferred an appeal from the second extension also. But that is not before your lordship. That is
That
before your
Milord will decide. That
437.
Milord will take Milord care of that. But this is a Milord parent order.
No, my lord, I am taking
my
your
lord.
lordship knows your lordship is a part of the larger bench. I'm taking this point. I'm sorry, my lord, but I'm taking this point that that appeal is pending
We'll
before
direct that to
37.
to appear along with this.
37, yes, my lord. That has to be released.
That has to be released.
That has to be
first.
released, my lord.
That's the reason.
That has
why
to be released
I'm saying
first.
That's all. the
Milord,
whole-
Milord, may I praise this, Milord? That has to be, this is a parent, that's a one-liner extension. As Milord Justice Orijit Banerjee was appearing for the A.H. Abdani family, he has released these matters. That's all.
No.
Milord, I cannot come straight away before your lordship. Milord, I have to cross that hurdle and come before your lordship. Of
Mr.
Milord.
Ghosh, then you take the preliminary objection.
Yes.
Start on that.
Yes.
We'll decide on that. That since it has been extended, this appeal is not maintainable.
Yes, and Milord, not only that.
You're leading, Mr. Ghosh. Yes.
And not only that, Milord, that appeal is listed in before another division bench. The
That will
division
get
bench has.
released today. It will be
Milord-
called on today. We'll get it released. We'll inform the court
Milord,
that Milord is.
I know that would be the, but we can't. As a Milord, if the appeal was filed, your lordship could have treated it in the days list.
No, the main
Main appeal is this appeal. This is only one-liner
Release.
extension. One-liner extension that
So what is fixed today before the division bench?
The extension.
the extension Milord had to file Milord appeal because otherwise that remains unchanged.
That depends on the maintainability.
Maintainability of this appeal.
Take the maintainability.
Yes.
What the division bench
Let him take the maintainability. May I proceed?
larger bench.
এটা কি বেস্ট ডিফেন্স মনে হচ্ছে Milord, may I press the order, Milord?
Yes.
Milord, the issue Milord pertains to Milord originating summons. Milord, it's not a Milord normal suit Milord that we come every day Milord. Milord, kindly come to Milord the impugned judgment, impugned order rather Milord, where Milord
Yes.
at last Milord. Yes. The
It was granted in your favor.
No, Milord, it was granted against me. Injunction was passed. Now, Milord, the originating summons chapter 13 of the Milord High Court Ordinance rules. Milord, I am carrying that. Milord, আরেকটা বই আছে বই দে
অরিজিনাল সাইড রুলস আছে এখানে দেখ দিন তাহলে আর আছে ওদিকে থাকবে
এটা মার্ক পেজ 73 বার করো একই বই
পেজ 73
73 বার করো 73 বার করো Milord, I'll getting another Milord, I did
extra copy
Milord, I have a copy Milord.
give one copy and we'll I have
Now, Milord, originating summons suit Milord does not contemplate an ex parte order. And Milord, it's being filed beyond the form Milord which has been prescribed by the Milord High Court Ordinance rules.
let's come to the rules.
Yes, kindly comes to Milord chapter 13.
Yes.
Now, Milord, kindly takes Rule 13. An originating summon shall be in form number 1, chapter 13, rule 13, and shall specify the relief sought. The persons entitled to apply shall present with it to the registrar or master an affidavit setting forth concisely the facts upon which the relief sought by the summons is founded, and the registrar or master were satisfied that the summons and the affidavit are in compliance with the chapter shall sign the summons and cause it to be sealed. No original document save with the permission of the registrar or master shall be annexed to the affidavit, but copies of documents sued upon, if any, and the wakalatnama shall be annexed to the same. So it has to be in form number 1. Justice Kumar takes page 456. The form number 1 is there of that book. Myler's
Appendix D.
Appendix D, form 1. At the back, Milan. Yes. Millet, I'm led by Mr. D. Millet. He has taken his break. Millet.
I'm grateful. Millet. What you achieve? Millet has seen form number 1, Millet? No. Millet has which book, Millet, if I may? Oh, Baba. Hey,
Judge Saheber kache tomar
450?
form 1.
Hey, ji. Justice Kumar's will be page 456 and Millet.
Yes, Sahib.
Yes,
Got it.
Millet.
Got it.
No, no, no.
Yes.
Oh.
Form number 1. Form 1.
Millet. Millet, this is the specified summons. Originating summons, your lordship is well aware, Millet, it's in more in the advisory capacity of this honorable court, Millet. So Millet will kindly see the summons, it starts with let blank of blank within 8 days after service of the summons on him, inclusive day of such service, cause an appearance to be entered for him to this summons. Now, Millet, why do we say here, Millet, within 8 days, your lordship will again come back to chapter 13, Millet, now. Millet has seen rule chapter 13, rule 13, your lordship has seen Millet. Then Millet will kindly see 14. This is the marking by your lordship's court. Then 15. The summons together with a copy of the affidavit shall be served by the advocate acting on the original side, taking out the same, and the summons after service shall be filed in the proceedings together with an affidavit of service. Next one, it says originating summons shall in ordinary cases be made returnable in 8 days. Now, that is the 8 days your lordship has seen in the summons. 8 days after service, but the judge before whom the summons is returnable may fix such longer period, not shorter period, but longer period. Then, let's see 16A. Party served in the originating summons shall, before he is heard, enter appearance by filing with the proper officer on or before the fixed date. Then, 16B. Sorry, I'm just reading it through. It's very important. Where an appearance has been entered by any party to an originating summons, the day and hour for attendance thereafter shall be ascertained from the judge through his officer, and notice thereof shall be given to the party or parties appearing. This is form number 2. Form number 2 will fix the date for hearing on the originating summons. If it also goes back to annexure D, appendix D, sorry. Take notice that you are required to attend at the chambers of the honorable judge for the hearing of the originating summons issued hearing. So before that, there is no hearing on the originating summons. And there is a reason for that, Just after that, if your lordship kindly sees, 16C is not important because where there is no appearance, it's not really too very important in here case. Now, on the 17, very important. On the hearing of the summons, where the parties thereto do not agree to the correctness of the facts set forth in the affidavit. So, the court has to first see whether what has been stated in the originating summons affidavit is agreed upon by the parties as admitted facts. Because this court in originating summons do not go into disputed questions of facts. Oh, sorry. The facts set forth, the judge may order the summons to be supported by such evidence as he may think necessary. It's only after this, supporting evidence is allowed by the court and may give such directions as he may think just for the trial of any questions arising thereto. The judge may make such amendment in the affidavit and summons as may seem to him to be necessary to make them accord with the existing state of facts, so to properly to raise the question in issue between the parties. Then, my lord, 19. The judge hearing an originating summons may, where he thinks fit, adjourn the same into court for hearing an argument. So, my lord, from the chambers, if it's found that there's an argument necessary, it goes up to the court. And where it appears to him that the matter in respect of which relief is sought cannot be disposed of in a summary manner, may refuse to pass any order on the summons, and may dismiss the same and refer the parties to the suit in the ordinary course. So, my lord, from here, your lordship will kindly appreciate that it does not contemplate, my lord, ex parte orders like Order 39, Rule 1 and 2.
Is there any bar?
My lord, I will point it out. First, my lord,
You are right. After hearing, it will be done.
it will be done.
But like in a suit also, after trial, it is done. After giving an opportunity. In other proceedings also.
My lord, why I say, my lord,
Is there any bar of grant of additive injunction? That is what it is.
my lord, I will point it out why I am saying this, my lord. My lord, this does not contemplate any.
Either bar or provision.
The chapter 13 does not contain anything.
Typical case for 151.
My lord, in original side, my
Bar
lord, in original side, my lord,
151 is not applicable.
but it will be applicable, but subject to the original side rules. Now, original side rules, my lord, when an application is to be
Chartered
taken,
High Courts also have certain powers, inherent powers,
definitely, my lord.
as Chartered High Court.
My
And
lord,
this is
that
the latest patent concept.
absolutely, my lord. But my lord, your lordship from the date of Manohar Lal Chopra, your lordship must have, my lord, 62 Supreme Court, my lord. From there, my lord, 151, yes, but to prevent injustice,
Yes, definitely.
to prevent injustice, not for the sake of asking.
So once you open that up, it's very potent.
But I will not go that far.
No, we are not bent upon granting injunction.
No, my lord,
We are
that
trying to understand the contour because I am not a regular in this.
I understand, my lord.
So
This
that
is
I can
more,
speak for myself.
my lord, this is, I believe it's more akin to Section 34 of the Indian Trust Act.
Yes, somewhat.
So, my lord, it's advisory jurisdiction where questions are raised.
Yes.
My lord, questions cannot be raised whether any.
Section 34 also injunctions are passed.
My lord, I'll point it out, my lord. Here, my lord, kindly comes to, my lord, Chapter 13,
Yes,
Rule 1.
yes. We were going through that actually in the.
So, my lord, what
in
are the
consideration.
questions here?
Yes.
What are the questions? Who will take this out? The questions are given, my lord, from A to G. First, my lord, Rule 1 will not apply to the petitioner plaintiff, if I may say so, my lord.
What is the question raised by them?
My lord, yes, this is very important, my lord. Kindly sees the,
The learned judge refers to paragraphs probably also. Paragraph 5 or something.
my lord, with humility, I say the order is not reasoned, but I will come to that later, my lord. My lord,
Paragraph 16 has been referred. Oh, that's the relief, right?
my lord, that is the question. What is the relief?
Oh, yes.
My lord, kindly appreciate. My lord, may I just have 1 minute, my lord? 1 minute. I'm sorry, my lord.
More than that.
But no, only on the procedure, but which fell from your lordship.
Procedure is all you are on in this.
If today, my lord, your lordship is of the view that an application can be made, I just am taking that from there, my lord. Where is the application?
An independent application was made or an additive
No.
order was prayer was made in that original summons.
Just in the originating summons.
Acha.
No application. Today, my lord, even if your lordship holds Order 39, Rule 1 and 2, my lord, your lordship knows original side rules. Without a notice of motion, there is no application. And now, very important, my lord, why I read this, my lord, kindly comes to the originating summons. Kindly see the originating summons.
Page 20.
My lord, page 20. Where is that? Kindly comes page 20, my lord. Is this the originating summons?
Form 1, no, sir.
Is this Form 1?
What is page 25?
20, my lord, 20.
No, 25, what is that?
Oh, 20, sorry, my lord, I'll just come to that.
20 you have seen. Yes. There is no interim.
25 is the summons. If it
It's
is
the affidavit in support, my lord.
the summons.
My lord, first an affidavit which is supported by the originating summons. 20 is the summons and 25 onwards is the affidavit in support of the summons. Man, it's a chamber matter. Your lordship appreciates my chamber matters.
Yes.
It goes with the master summons Here it's the originating summons.
All right.
So it's marked as CS with the OS in bracket. Now kindly see my page 20.
Hmm.
Well, is this an originating summons? I'm asking myself, my lord. Form 1. What is this?
Form 1 contemplates 8 days notice.
When the business of the court.
Why is this not?
My lord, let us come
to the form.
Yes, my lord.
We are at the
457.
form.
এই
Yes,
গোলাপি গোলাপিটা হ্যাঁ
my lord, may I start, my lord?
Yes.
Let blank within 8 days after service of this summons on him, including a day of
The
such
first two
service,
blanks are the name and the address. It is up to yes.
cause an appearance to be entered for him, which is issued upon the application of blank,
Yes.
claimed to be for determination of the following questions. Where is that 8 days notice? And this is not an application. It says, Malad kindly sees the page 20. Or soon thereafter, as and when the business of the court permits for hearing of an application.
Technical error, but the substantive provisions. Substantive
No, Malad, it is not with humility, I say, Malad.
not.
Because, Malad, 8 days is given by the rules.
That's the prayer, but rules permit the court to put it within 8 days or more.
More, not less.
So therefore, it says on the phone or so soon thereafter. So what is wrong in that? 8 days or thereafter.
Malad, I have to enter appearance on 8 days.
Yes,
Malad,
but
summons.
what is the wrong in this?
But this does not talk about
This-
entering appearance. Malad, like a writ of summons. Yeah, Malad, no. Like a writ of summons, Malad.
Yes.
But this is not technical, Malad. There is a reason behind this. Malad, on this appearance, Malad, in Rule 16, the
There
facts.
is no nature of claim is not there. There has to be a separate state the nature of claim and state the question.
That is not there.
There is
Following relief.
oh, acha, yeah.
Following reliefs.
The following questions and or matters.
For the following reliefs.
They say
They say for the following reliefs.
Oh,
And for determination. With regard to the administration of the estate.
it goes outside whenever they say reliefs, it goes out of the scope of
That is what I'm. Malad, they
Be a regular
coupled
suit.
together.
should be a regular suit.
And they've coupled it together. Notice of motion or Malad master summons. There, Malad, you have to, without a notice of motion, master summons, Malad, no application.
And claims to be the form says which is issued upon the application of such and such. Was it should be who? In my book it is was claims. It should be who claims.
Who claims, Malad?
Who claims to be state the nature,
Nature of the claim.
They have to state their locus standi and nature of claim.
Yes. And then, Malad, for determination of following questions.
No relief is contemplative.
Why, Malad? Because I pointed out, both parties will come ad idem to the facts. If not, then evidence. Then your lordships will decide whether this evidence can allow the lordships to proceed under summary jurisdiction. An expert is not contemplated.
Otherwise, in the garb of an originating summons, a summary proceeding is sought in a
Yes.
regular suit.
Yes. And Malad kindly sees, Malad, on this originating summons, Malad, kindly sees F.
But 13, rule 13 says an originating summons shall be in form number 1 and shall specify the relief sought. That is
Yes,
an
my
action
lord.
used in 13.
Form number 1. So relief is, Malad, the questions to be determined.
Let's go back to 1 under the plus under any section. For such relief of the nature of the kind following as it says, Mr. Rai,
Malad.
1 as of course an originating summons returnable before the judge sitting in chambers
Chambers.
for such relief of the nature or kind following as may by the summons be specified and the circumstances of the case may require. That is to say, connects the determination without an administration of the estate or trust of any of the following questions or matters.
Malad is reading, Malad, if your lordship kindly, I missed that, Malad. Rule 1, my lord.
Sorry, very sorry.
Sorry, my lord, I should have.
Rule 1, we have started from the middle. That's why.
Yes, my lord. Executors or administrators of a deceased person or any of them, and the trustees under any instrument or any of them, and they are not falling under any of these, and any person claiming to be interested in the relief sought as creditors. Well, that is a different point altogether.
No,
my lord.
not that. After
That is, my lord, 6 and 7, my lord, if your lordship kindly sees. My lord.
Yes, very yes.
Or as beneficiaries under the trust of any instrument, or as claiming by transfer or otherwise, under any such creditor or other person as aforesaid, or the surety of an executor or administrator may take out as course
After that,
returnable before the judge sitting in chambers
then
for such relief of the nature or kind following as may by the summons to be specified and the circumstances of the case may require, that is to say the determination without an administration of the estate or trust. My lord, why I emphasize, my lord, it does not contemplate any orders of administration,
No.
like injunctions and things like that, my lord. That is also an administration. And my lord, this will be read with, my lord, Rule 13. An originating summons shall be in form number 1 and shall specify the relief sought. The person entitled to apply shall present with it to a registrar or master, setting forth concisely the facts upon which the relief sought by the summons is founded, and the registrar or master were satisfied that the summons and affidavit in compliance with this chapter shall sign the summons and cause it to be sealed. And then, my lord, 15. The summons together with a copy of the affidavit shall be served by the advocate acting on the original side, taking out the same, and the summons after service shall be filed in the proceedings together with an affidavit of service. Then, my lord, kindly see 16. Then it becomes returnable.
3 steps.
Then it becomes returnable. And after that, my lord, your lordship will kindly see, my lord, 17. That is very important, my lord. If your lordships, my lord, go into the questions of fact, prior to this, my lord, where is that finding by the court that there is dispute in the facts, which will bring in evidence? And that is where your lordship will decide whether the evidence is strong enough or the dispute is so large that it will not go into that question in an originating summons, but send it to a regular suit. One is that, my lord. This is the summons.
Yes.
Today, my lord, an interim application cannot be made in the air, my lord. There is no interim application. No GA, no IA. We now have made it as IA. There is no IA. There is no application. My lord, we generally have a pleading for an order 39 rule 1 and 2.
Can there be an independent application in connection with an originating summons?
My lord, I am giving them the best option. Yes, it can be, if I may say so.
Unless it's a suit.
But if it is not so,
The suit or proceeding in the eye of lawyer.
it is without the summons, it is marked as original, my lord, CS. My lord, it is there, my lord. I will not say
Absence
something.
of better nomenclature, probably.
But it says CSOS. Yes, and bracket OS. My lord, that your lordship will find is given by the rules again.
No, but yes.
In
No difficulty
14,
in
my
that.
lord. The affidavit, where accepted, shall be filed and numbered as an ordinary suit and entered in the register of suits. But after the serial number of the letters, OS shall be placed. So, my lord, will kindly appreciate, my lord, today, my lord, my first submission is, my lord, there is no originating summons.
No originating summons means because of the format.
Summons is not in form.
All right.
For the court to take cognizance, my lord, it has to be, my lord, under the originating
So
summons.
primarily 2 questions. This summons is not in form. Secondly, there is no scope of passing in ad interim or interim order unless the first hearing is there. Section 7, Rule 17.
Yes. And even, my lord, taking my worst case, my lord, I generally tend to take that yes, it is possible. Where is the application?
What is the reason for passing the order?
I come to that.
There has to be formal prayers supported by
Yes.
these are not.
My lord, the prayers, if your lordship sees on what basis it has been passed, my lord, kindly sees, my lord, it has been passed on the basis of question. My lord, kindly takes the originating summons,
Yes,
my lord.
yes, you're right.
They have, my lord, gone on the basis of, my lord, page 21, E and F. My lord, these are advices of the court, my lord, with humility.
These are not reliefs.
Whether an order to appoint a suitable person as receiver, assets and properties would oversee the entire function of the said trust. Whether an order to restrain the said companies and an F from transferring and or alienating, dealing with and selling and or encumbering and parting with any of its assets, jewelries and or money kept in savings bank account and fixed deposits till disposal.
These are a question.
Allegation has been made in para 19.
Yes. Well, I'll come to that allegation now.
There is no scope of seeking any interim relief also probably in an originating, and they have not sought also.
No.
Reliefs and questions are interchangeable terms in the sense, in that
Yes,
sense,
Manoj.
under rule 1.
Has to be because
Languages, yes. May
when an
take out-
opinion is given, that is the relief.
may take out such and such for such relief of the kind following and the circumstances of the case may require.
Yes.
So such relief may take out an originating summons for such relief the determination of the following questions or matters. Very well. The sentence does not make sense actually in rule 1. It's not a complete sentence. Maybe the British had different notions, but they knew better English. Could have.
And we don't know if we go by the number of people speaking Malay, then we know
No,
better English.
English is as much an Indian language as any other language because we have adopted our English. So very well. So you
Malay now kindly comes to page 34.
Right. Yes.
Just after the Malay questions framed. These questions are questions of law and do not require any detailed evidence or fact finding, and as such can be answered by this honorable court.
May I come back in a minute? Just
Yes. Yes.
Then Malay kindly sees it talks about a majority shareholding. Malay, may I just give a very short background from where this is coming, Malay. This is a dispute between Malay, the Wadhwa family. Now, Malay, their Malay, letters of administration had been issued in the name of Malay, Onushwa.
With will.
Pujara.
With will. With will.
No, without will.
With will.
No.
Without will.
Without will. Malay, that letters were issued and Malay effect was given. After that, Malay, the plaintiff Malay had initiated a revocation application of the letters of administration. That is pending before this honorable judge. And Malad hearing has been concluded. Now, Malad, on the basis of that, they say that they have filed an injunction application in that proceedings. In that proceedings, they filed an injunction application, which is also pending hearing there. Malad, on the basis of that, they make out a case that they are having an interest in this trust and trying to, Malad, take whatever orders.
In the identity model, no order was passed there in that injunction application.
No.
Not passed. Mr. Ghosh says no. Mr. Ghosh says no.
No, Malad. But I get confused, Madam. Sorry.
No, he's saying
No, Malad. Mr. Ghosh
is what? As mischievous as you are. No, much more.
No, Malad. I'm more.
He's more.
I'm more.
Anyway, we'll
But he tells me
cite in a proper when questions are framed and originating summons.
but he refers to me in a specific name. He calls me Babyface Nelson.
Nelson.
He is a famous gangster in India.
He says I'm a Babyface Nelson.
Yeah.
So Malad now kindly sees Malad 17. The plaintiff says the majority shareholdings in Wadhwa Endowment Management Private Limited and Jerome Bhai Management Service Private Limited was held by Damodar Das Wadhwa. Malad, this is the person whose properties when letters of administration was taken. Damodar Das.
As of today, you have the letters of administration.
My mother had. She has passed away.
Achha.
Today I have been substituted there. I've also taken this point, Malad, that after Malad, it has been already Malad.
Do the letters
but
of
we don't-
administration devolve?
Mr.
It doesn't.
Mr. Ray is now representing the companies, not mother or
No,
father.
no, let me come to that. No, there's nothing to, Malad, that is their case. I have to take it from there. Malad, that letters of administration was issued in the name of the mother.
Right.
Now the son has been made a party in that because the mother is no more. And now, my lord, kindly sees what they have said.
So how are you bothered with the companies?
Companies also, my lord, I'm representing. I'm for the company.
No, no.
today.
How are the companies embroiled in that letters of
My
administration?
lord, let us see that now. I'm reading that. My lord, that is their case. My lord, kindly sees their case. Upon the death of Damodar Das Wadhwa and grant of letters of administration in favor of Onuswa Pujara, the said shareholding has been transferred in the name of Onuswa Pujara. After the death of Damodar Das Wadhwa, son of Onuswa Pujara, being Nirmal Pujara, was appointed as one of the directors of the said company. And after grant of letters of admission in favor of Onuswa, wife of Nirmal Pujara being
98.975% shareholding.
yes.
All right.
Documents evidencing shareholding and directorship patterns of the aforesaid companies are annexed and marked with the letter D. Plaintiffs reasonably apprehend that the entire holding of Damodar Das, now parked in the name of late Onuswa, will ultimately go to Nirmal and Jayant Pujara if not already inherited by them.
So they should have filed a regular suit
That is what I want.
where they would have to file and satisfy the file an injunction and satisfy the court on the facts. By way of formulating questions, they cannot get
They
this.
cannot get this.
That is what you are saying.
Because I have read Malat their first pleading, the question of law only involved.
No, they have to comply with the format.
Yes, but Malat, is that
That also they have not.
Malat, they have that they have said. But Malat, can that be Malat compared with the pleadings? That is only a question of law.
So they'll probably pay on the word relief in Rule 1.
Yes, relief.
It boils
But
down to
relief
that.
has
The
to-
relief is inextricably intertwined with this questions. Whether
But
the
Malat,
same-
again, Malat, I am on the fact part where your lordships will see whether first Malat, I will have to come up and say, yes, the facts are what has been pleaded in
yes,
this.
Rule 17 is there.
So if that is not there, Malat, then it cannot be only a question of law.
Yes, both grounds. Both
That-
grounds. Whether at all these reliefs can be seen as independent reliefs apart from the questions, and secondly, even if that can be unless 17 is complied at that stage,
Well,
before that it cannot be done.
Now, Malat, kindly sees 19 very quickly, Malat. I'll just finish very quickly, Malat. Entire ploy of Nirmal and Jayant is now to siphon away the sums parked in the said trust through these two companies, namely Wadhwa and Jerambhai, into other entities or back to them, and some of them in complete contrast to the objects of the said trust and beneficiaries service to the named deities. And as such, is pertinent that companies, namely Wadhwa and Jerambhai, be restrained from acting as trustee of the said trust.
That's completely past. No,
Now, Malat, this has been made into a question. This is a question.
Hmm.
And is it a question for administration? Or is it to prevent? Malat, I'm taking my worst case again. Prevent usurpation.
Yes.
Now, Malat, may I just straight away come to the
Probably they mix up directorship and shareholding. Director, how many directors are there? There are other directors also.
Malat, I think there are two directors.
Although that's not mentioned here, so let us not go into that.
Malat, again, the facts. Then I would have to come up with the facts, Malat.
Right.
Now, Malat, kindly see next page, page 37.
Hmm.
Sorry. Malat, para 22.
Hmm.
Balance of convenience income is wholly in favor of passing the orders as paid for in the originating summons. Unless orders are paid for passed for in the originating summons, the plaintiff will suffer irreparable loss. Instant affidavit in support of the prayers made in the originating summons is made bona fide for the ends of justice. So, Malat, it is again a coupled pleading. Why I say, Malat, kindly comes back to chapter 13. Chapter 13, Rule 20. Very important, Malat. Where the judge is of the opinion that the matter is fit to be dealt with on an originating summons, he may pronounce a judgment as the nature of the case shall require. And Malat, whatever orders will become a decree.
Hmm.
So, Malat, if they are asking for orders in the original, it becomes a decree without hearing me. Now, Malat, may I just take your lordships to the order under appeal, Malat.
Last one. This one, একদম last.
It's the last.
Last. First year.
Last no, not to memorandum में था. But kindly seize the order. Sorry, my lord. Keep me. Keep me. What's the name? Well, sorry. One is reading the order, my lord. My lord, such and such files has filed the present originating summons seeking an opinion from this court. So the judge was of the view it's an opinion which is being sought, as appearing para 16 of the present suit, out of which one opinion is whether an order of restraint of the said companies from transferring. So, my lord, if it's an opinion, then it becomes a decree now. Mr. Sansar, appearing for the plaintiff, the plaintiff is the widow of such and such, who was the son of one of the brothers of Damodar Das Jerambhai, who died on 29 July 2022. The plaintiff has already filed an application being GA1 in PLA, praying for recalling, revoking of the grant passed by this court in respect of the will, dated, well, I think there is something, I don't think there was a will, or whatever, and the said application is pending for adjudication. Mr. Sansar submits the majority shareholding, my lord, that, your lordship, is that paragraph which has been set out, my lord. Then, my lord, 5. The plaintiff came to know that the deed of appointment has been made on 14 December 2010, wherein 2 of the companies have been made as trustees of the defendant number 1 trust. So, my lord, these companies, admittedly from 2010, are trustees.
Filed in February.
And, my lord, they have filed this in February
Waited till August.
and moved in August. Then can you see next page? Submits that the company cannot be made as trustee of the trust. He has relied upon the judgment of State Bank of India versus Mouranga, reporting where the Honorable Single Bench has granted the interim order in the originating summons suit is duly confirmed by the Honorable Division Bench. But with humility, my lord, this is completely a finding which is contrary to the judgment. I'll be placing that judgment, my lord. This has been regularly been interpreted in this fashion by the single judge. With humility, I say, but obviously, my lord, it is my opinion, my lord. Your lordships I will try and place it, my lord. And thereafter, my lord, has relied upon an unreported judgment, my lord, Shekhar Guho, again relying on that judgment, my lord, State Bank of India. Considering the submission 8, my lord, made by the counsel of the plaintiff and perusing the materials on record of judgment relied by the plaintiff, this court finds that 2 of the companies are made as trustees of the defendant number 1 trust. Plaintiff apprehends the said companies to alienate the property and application pending for revocation of the will. In the present suit, plaintiff seeks answer and opinion from this court. Considering the above, plaintiff has made out a prima facie case balance of convenience in favor of the plaintiff. Where is that pleading? Accordingly, defendants are restrained from transferring any parting with any of the assets into the amounts lying in the bank accounts and the fixed deposits till 22nd August 2025. Plaintiff is directed to issue notice of the defendant immediately. That should come first, according to the rules. And to file affidavit of service on the returnable date. Without that, it could not proceed in Form 2. Now, my lord, may I just place this judgment, my lord, with humility, my lord? Kindly come. State Bank of India versus Mohura gang and Gulam Tea Estate.
Enough.
You too.
Ladies.
হ্যাঁ এবার ব্যাংক গ্যারান্টিও করতে পারবি অরিজিনাল সামান্সে ওয়েদার দ্য ব্যাংক গ্যারান্টি হ্যাঁ বাট তারপরে অর্ডারটা দেখিস নি তুই না my lord, kindly takes this judgment, my lord. My lord, what fell from your lordship is the first sentence of this judgment. The rules of the High Court at Calcutta, my lord, has special significance in regard to the procedural aspect for the purpose of due administration of justice. It has stood the test of time, the power of the High Court to frame of rules having been preserved under the latest patent, saved by the provisions of the CPC. Time to time, the High Court by resolution added rules of the original side, which are also being saved by the letter spent in the court of civil procedure and binding effect in regard to the suits instituted in the original side of the court and certain other matters related thereto. The matter in issue in this appeal is Indian Instituting 1, Chapter 13 of the original side rules, para 3 of this court provides a special procedure by way of an originating summons, which had its origin in English rules of Supreme Court. This is undoubtedly a suit in the original side, but cannot be equated with it, since other rules of questions are framed for the purpose of being answered by this court, and the court in its turn considers as to whether questions are within the ambit of the rules of the original side and can be conveniently dealt with by way of an originating summons. In the event, however, the court upon such consideration finds it otherwise, the court will relegate the party applying to it as an ordinary suit. Then in the matter under consideration appears that the plaintiff respondent has applied before this court under Chapter 13 of the rules of original side of this court by way of an originating summons and obtained an ex parte order of injunction restraining the enforcement of a bank guarantee by way of an ad interim order of injunction interlocutory relief. On the returnable date, the appellant herein pressed for vacation of the ad interim order on the ground that in the facts question of having an originating summons taken out by a party does not arise far above the grant of an interlocutory order of injunction, since Chapter 13 of the original side rules and this court deals mainly with construction and interpretation of instruments and other documents, and no final relief has been prayed for, can be granted under an originating summons. The learned judge, however, was pleased not to vacate the same and directed filing of affidavits. It is at this stage this appeal has been preferred, the grant of ad interim injunction on the plea of demurrer that an originating summons does not lie for the purpose of grant of relief as prayed for in the summons, since all interlocutory orders in aid of the main suit, no ad interim relief can be had in facts and circumstances of the case under consideration. Then Malad kindly comes to paragraph 8. Malad kindly identifies Malad paragraph 7, Mr. Shorkar, appearing for the appellant, contended the court has no jurisdiction to deal with the matter in issue. But this will become important. I will point out why a bit later, Malad. So Mr. Shorkar was opposing the originating summons. Only this much, Malad. Malad 8. In order to appreciate the contents, it would be convenient at this stage to consider the language of the rules under Chapter 13. And Malad, then the rule has been set out. I'm not reading that. 9 is Malad, who may take out originating summons in respect of what matters is given. Malad 10 is with regard to vendors, Malad. That is a different concept altogether, Malad. Vendors and mortgage. I'm not on that, Malad. Kindly comes paragraph 11, Malad. Strong reliance was placed on rule 9, 14, and 17, which read as follows. Malad, this is Malad what I had also placed, Malad. 17 is what I'm on, Malad. I have already placed. This was also considered here.
9 and 11. This one.
Then 10, Malad, these are discussed, Malad. This is on the facts of the case. But I will just take your lordship to paragraph 16, Malad.
Yes.
According to the plaintiff, upon the construction of above noted 2 agreements, the appellant number 1 is not entitled to claim, and the plaintiff is not liable to pay interest upon the interest for delayed payment if any of the installments thereon. In the circumstances, plaintiff stated that the following questions arise for determination by this court under Chapter 13. Now, Malad, the questions are given. Then, Malad, kindly sees 18. For the grant of an interlocutory relief, the plaintiff's averment ought to be noted in extenso. In paragraph 20a, the plaintiff stated, and Malad, it is given, and Malad, case is made out for a ad interim order. 19. It is on this background the plaintiff also prayed for an order of injunction as the interlocutory relief, restraining the appellant for enforcing the 2 bank guarantees in favor of the appellant. Strenuous submission have been made as regards the prayers in the summons and the questions framed for this court to answer in the body of the plaint. And as to the prayers in the summons ought also to be noted here. The prayer read as follows. But it will kindly see G. The next page, G. Injunction prayer included in the summons. Then, Malad, 20 talks about an apparent inconsistency regarding the questions raised in the summons and in the body plaint filed under Chapter 13.
What is this body plaint? The affidavit? That affidavit?
That is the affidavit. That is the body plaint, Malad. So, Malat, there was a
Is it generally referred to as a body plaint?
body plaint, because that is the plaint, Malat, very loosely connoted because it's an affidavit, but it is the body plaint, Malat.
All right.
And raised in the summons and the body plaint.
Para 20, read it, Mr. Rai, because that's relevant.
Yes, Malat, I'm reading it because they will refer to that.
They will obviously refer.
Yes. Complaints as to form of the summons, though strongly commented upon by Mr. Shorkar, appears for the appellant. But in my view, the same do not go to the root of the points raised in the matter under consideration. Malat kindly appreciates why this was stated, because Malat, Mr. Shorkar had shown an inconsistency between the questions. I'm not on that, Malat.
Not on the power of the court to grant.
I'm not on that.
He was on the discrepancy between the originating summons and the body plaint.
It's not a summons at all. Here it's a summons with wrong or discrepant prayers or questions. Because, my lord, your lordships, remembers, my lord, in the rules it is provided, the court can amend the grounds also.
Yes.
So, my lord, if there is something in the discrepant, the court always has the power. But the court cannot have the power, and with humility, I say, my lord, that the entering of appearance is not required. Before that, I will pass an order. I've shown, my lord, then 20, any order becomes a decree then. Now, my lord, kindly sees 21. Mr. Malat kindly keeps note of this paragraph. This will become important at the very end, Malat. I'm sorry. Mr. Shorkar, next content is the court has no jurisdiction to deal with the matter in issue by way of an originating summons in chapter 13 of the rules of original side of this court deal mainly with the interpretation and construction of documents and other instruments and determination of questions for declaration of rights only. No further relief or any consequential relief of any kind by which injunction can be granted, so the court in an originating summons cannot go into the matter and grant relief. In any event, it was considered that Rule 10 makes the position clear enough as regards its applicability, since it is a discretion of the court, and the court ought not to grant any final relief apart from declaration in an originating summons. It was contended that the claim of the bank arose out of the agreement under trade usage. On this court, reliance was placed on Paget's law of banking. This will not be very important. I only read that first part. First part, Madam Mr. Shorkar was of the view that ad interim orders cannot be passed, ought not to be passed. This is a submission. Now, Malad kindly sees, Malad, several judgments are placed. Malad, I'm not going into that. Malad, only Malad 23. The decision in Lewis and Green was considered by this court in the case of Gokul Chandra De and Gopinath De, reported in AR 52 Calcutta 705. In that decision, this court observed, in the present case, answers given by the learned judge on the question of construction have not disposed of the summons and have left certain questions unanswered. Moreover, in the facts of the present case, the pleas and bar raised by the opposite parties, if sustained, might render the question of construction unnecessary. On the above grounds, I am of the opinion that the court should not have adopted the procedure by an originating summons, but should have relegated the parties to a suit. Mr. Shorkar submitted as a matter of fact, the learned trial judge ought not to have entertained the plain. Since the plain reading of the correspondence exchange with the parties is apparent that the claim lodged by the appellant is in regard to the charge of interest in terms of trade use and customs available to a banker against his constituent. Thereafter, several other judgments. Then your lordship will kindly come to the finding.
Para 31 would be important for
yes, 31, 32. Our notice, in my view, do not lend any assistance to the contentions raised by the plaintiff. The same are clearly distinguish the facts of the case. Justice Artsbury in Leicester Corporation's case categorically recorded that in the event there being a question of fact, the matter ought not to be dealt with by way of an originating summons. Before, however, proceeding with the matter and any further, two other decisions ought also to be considered. These have been raised, two judgments. It kindly comes. I'll just read a bit of that. Lord Justice Cotton, there may be questions of the validity of the mortgage in regard to the position as trustee. Question of priority does not arise in the administration of the trust. judge decided either that he had no jurisdiction to decide the question of priority of the mortgage upon an originating summons, or that if he had, it was not proper to decide in an action commenced in that manner. I agree with him. In my opinion, the court has no jurisdiction to decide such a question on an originating summons, but I decidedly hold that if it has jurisdiction, it's not proper to decide it upon an originating summons. But I'll just pause here for a moment, Malad. When a pleading is made, that a balance of convenience is in favor or not in favor, that itself shows the disputed facts, where the court is being drawn to decide on the balance. Now, Malad, the last sentence there. I am of opinion that it would be very wrong to decide such questions as this is in these informal proceedings. This mode of procedure is better to decide matters which are not of an involved nature and not questions which require considerable discretion. Then, in my opinion, the decision of Mr. Justice North was right. With respect to the question of cost, we cannot deal with that as we have upheld the decision and he has exercised the decision concerning them. In the same decision, Lord Justice Lindley observed kindly, it is there, it will kindly come to the after 33 in the middle. Other decision ought also to be noted in this context. Decision in case of Locke versus Pierce, where Justice Lindley observed, it is what is technically called an originating summons, asking first for a declaration that there was no forfeiture in fact by reason of the breach of covenant to repair the premisal. Pause there to ask if any chancery practitioner ever heard of such a thing. Obviously not. Their right was to proceed by an action commenced by writ. An originating summons is a process introduced in order to save cost and is not applicable to such a case as this at all. Then the summons proceeds to ask, in the alternative, for an order for relief against the said defendant's right of re-entry and forfeiture upon such terms as the court may seem fit. Whether that relief can be given then depends on the true construction of the action. Then the summons goes on to ask for an injunction by one prohibition or otherwise restraining all further proceedings upon the judgment in the actions of illegal in the court on the order, amongst others, or what appears. For such a purpose, an originating summons is utterly inappropriate. Be it noted here that the point for considering the matter under consideration is whether own the defendant any money, which is entirely a question of fact. So, this is now coming back to this judgment, para 34. Whereas the appellant contends the claim of the bank is based on trade dues and customs as also for damages, respondent contends since the term loan is converted in terms of an agreement, question of payment of interest or interest due agreement. This is on the factual part. Then Mallet kindly sees 36. In my view, it would neither be appropriate nor expedient to decide the question as raised in this proceeding only on affidavit evidence by way of an originating summons. Originating summons available to proceedings are not of an involved nature and on which there would hardly be any scope for any oral evidence. Having regard to the issues raised and the questions posed for consideration, one cannot dispense with the oral evidence. While it is true that the court has power to have even oral evidence, but in my view, the same ought not to be extended to any suit under Chapter 13 of the rules of the court. Otherwise, the Code of Civil Procedure would have to be given a complete go-by. Needless to say, however, that the Code of CPC prescribes certain forms of decree which is not available to an originating summons. The intent of the rule makers could never be to give a go-by to the procedural aspect under the Code of Civil Procedure. For the purpose of due administration of justice in a manner peculiar to the original side of this court, these rules have been framed. Even a plain reading of Rule 6 of Chapter 13 of the original side rules, it is to be presumed that interpretation and construction of deeds and documents only ought to be taken note of, and not each and every suit for mortgage, for sale, foreclosure, or redemption. That obviously was the intent of the rule makers. Otherwise, Rule 10 would not have been engrafted in the rules, which provide that the court or judge shall not be bound to determine any such question of construction when his opinion is not to be determined on an originating summons. Had the intent of the rule maker been otherwise, Rule 10 would not have been found placed in the rules under Chapter 13 of the original side rules. In regard to the question of the construction, the Chapter 13 has been engrafted in the rules of original side, but not a substantial question which would finally determine the issue. Assuming everything in favor of the plaintiff contention, convenience and expediency prompts this court to hold that originating summons is very restrictive in its application and cannot be taken recourse to any and every matter, even under Rule 6 of Chapter 13 of the original side rules, Apart therefrom, the correspondences such as trade usage and bankers' rights to charge interest for delayed payment. Then, on that state of facts, I am of the opinion that originating summons under Chapter 13 of the rules of this court was not the proper mode. In the present case, the dispute cannot be adjudicated only upon interpretation by way of and construction of the deed of mortgage or the deed of guarantee. Malad kindly appreciates the statements made in the originating summons affidavit, Malad. There itself, they have raised the dispute. Then, Malad. Now, this is the most important part, Malad. Just after the view expressed above finds support from Daniel's chancery practice. Has the Lordship got that, Malad? Wherein it has been categorically stated that the object of the order is to enable the court to decide question of construction. The decision will settle the litigation between the parties, not questions which, if decided, one only will do so. It is further dated that if no question of construction arises, the court, even if it has jurisdiction, will not give partial relief by making of declaration of rights of the persons interested. In the view I have taken as noted above as regards to maintainability of originating summons in the facts under construction, I am not expressing any opinion as regards to grant of interlocutory relief by way of an injunction or appointment of a receiver in originating summons. And as such, the cases in this court need not be dealt with exceptional recording the passage cited in Ojas and Atkins. Pleadings, as also Daniel's charges, do not have any bearing in the facts of the case under consideration, since the views expressed related to adverse action. And I find some justification in Mr. Shorka's submission on that score, para 21. In the premises, there have been success on the ground of non-maintainability of originating summons. The order of the learned trial is thus set aside. Now, Malad kindly sees the finding of the Honorable Judge passing the order, Malad.
August 1 order.
Malad, paragraph 6. Mr. Sanjay Sami, the company cannot be made as a trustee. Relied upon judgment in the case of State Bank, wherein the Honorable Single Judge granted the interim order in the originating summons suit, which was duly confirmed by the Honorable Division Bench. And now, Malad, kindly see Shekhar Guho.
Yes.
ও আজকে নিয়ে আসুন আমাকে একটা দেশে করবো না কিছু করেন না কিছু করেন তাই জানি যাচ্ছি না মানে
This is why we request you not to cite our own judgments. Because if you cite our judgments and we rely on those, that will be this perpetuation of the
yes
same view. The underlying argument which you are making by citing this judgment is the reason which we ask you not to cite these our own judgments before.
I did not intend to, but
But let us see the logic here. If there is something
yes,
else, then
come to that, just give me a moment, Malad.
yes.
Yes, 29. Malad, this is more, Malad, far. Malad, and it is, if I may say, Malad, there is a reasoning here.
That is what we want to see. It's
Yes.
Independent reasoning.
Yes, well, let us see that.
Sir,
Plaintiffs have filed the present originating summons against the defendants, praying for an opinion of this court on several questions raised in para 38 of the instant suit. Counsel plaintiff prays for an ad interim order of injunction restricting the defendant from operating or transaction of the bank account number such and such maintained by the trust with State Bank in the name of the trust. A trust deed was executed with respect to such and such, wherein clause 7 and 8, the name of the beneficiary of the trust and the number of trustees have been mentioned. As per the said clause, plaintiffs and defendants are either beneficiary or trustees of the said trust. Clause 10, it goes on, Malad, deciding on the reading out the trust deed. Then, Malad, page 2.
this question was not raised because no one was there to raise it.
No, but why I'm relying on this, Malad, I'm trying to show this judgment, Malad. Malad, they have relied on this, Malad. That is why I'm
They
just
have relied saying that the court had also passed an interim order restricting.
That is it, Malad.
This court, the same court.
Yes.
So,
Malad,
but learned judge does not rely on that only.
no, Malad.
They
the
cite
question-
it, but that you yourself have passed this order,
Yes,
which
that
is
is what they've done.
which is quite normal. I mean, no difficulty.
But Malad, showing that other judgment, Malad,
That, yes,
that,
that
my
takes
lord,
to
I
consider.
believe, my lord, that has been the basis also to bolster this
That is the
judgment.
primary basis of this.
Yes. Because, my lord, we'll kindly see in this, in page 4, my lord, of this judgment, my lord. And it kindly comes to paragraph page 5, sorry, not 4, 5. Very interesting one. That is what I wanted to show, my lord. The plaintiffs are directed to serve the copy of the application
Paragraph,
and
the
page 5.
yes, page 4 is the last page.
Huh?
Internal page.
I'm sorry.
Oh,
5
this is Rao's judgment. This is the last page. Is internal page 4 is the last page.
My lord, the Shekhar Go matter.
Oh, Shekhar Go, your side.
I'm sorry.
You're still with Shekhar Go. Your obsession, sir.
Yes.
We cannot go out of Shekhar Go and Shamuli Vasu.
My lord, just comes to page 5,
5.
last para.
Yes.
So, my lord, there was an application made. Plaintiffs are directed to serve a copy of the application along with plaint.
Chapter 13 should be scrapped. Otherwise, this will take
No.
unnecessary time of the court. Regular suit, file an injunction, get an order.
If you need an injunction.
This legacy should be now stopped.
But, my lord, if you need an injunction, my lord, it was never intended. The intention was where, my lord, trustees, administrators.
File a suit and an application, the court has to formulate the questions. I mean,
But this was an easier route.
but this probably is in a different paradigm.
That is what I'm trying to, my lord, point
You
out.
have a point there that you frame the questions, the formulate the questions, and in one paragraph of the State Bank of India judgment, it has been held. This is not a pure question of law. So questions of law are formulated, and these are the issues, and that takes the shape of a decree. Means those are involved as issues between the parties.
My lord, one
And
point.
even now, there can be scope of interim order, not interim, but directions may be given.
Direction same.
under
My lord, there,
17.
that is why, my lord, I was
Under
just,
17 after affidavit.
that is what I'm on, my lord. The court must find out whether facts are addendum or not.
We also have to keep in mind that whatever order is passed becomes a decree under
That
20.
is-
There is no distinction.
That's why I wanted to show, I showed, my lord, rule 20. And the services afterwards.
Yes, like passing a decree and then
That is what is happening. my lord. And, my lord, with humility, my lord, it doesn't have a reasoning, my lord.
Even paragraph judgment.
But I would have shown judgment.
but
These are,
the clause rule 20 contemplates upon hearing after
Party-
17, 18. After
yes. So, my lord, as I was saying, my lord, the entire proceeding is half on one
the
boat,
language is any order, so that thing comes.
half on one boat, other one on another boat. Even the summons stroke, notice of motion stroke, master summons. It has become everything together. Similarly, the order is somewhat like that, my lord.
And as you said, there is no bar, we said, but the scheme of the things is different. Probably.
That is what I'm on, my lord. That's why I said, my lord,
No provision.
if there is no, but there needs to be an application because, my lord, the original side rules also say applications under notice of motion. My lord, there are judgments galore, my lord, that without a notice of motion, there is no application.
151 also, as you said, cannot be in thin air. I mean, we cannot exercise 151 just like that. I sit here and say that you have a dispute to verbally submit, then I could also use
That is
that would be setting
even more of the nature of an oral player.
totally arbitrary.
And, my lord, that is why I showed Shekhar Basu. Shekhar Guho. Shekhar, sorry, my lord. I don't know why his name. I've always been in awe of him. I still, my lord, maintain quite some distance.
This is damage control.
No, no, true.
In Bengali, managing.
My lord, the first day when I
Bengali is much better. Damage
day when-
control is too large, higher.
my lord,
Managing is
first day when I entered into court, my lord, I faced two persons, my lord, not just 1 minute, my lord.
faced in the sense.
Faced as in first day I knew no one, my lord, in this court. So I was there and Justice Oshim Rai, as his lordship was then, my lord. I was his chamber colleague. So he suddenly,
You started your practice in the criminal side.
my lord, yes, my lord.
I didn't
I was
know
with
that.
this, Mr. Bolai Rai, my lord, late Mr. Bolai Rai.
He was an expert in civil, criminal, everything.
Yes, yes, yes. 17, before that, he was always in civil suit. My lord, Mr. Basu suddenly looked at me and told Mr. Justice Rai, he's of your chamber. He's not buttoned his coat. First day, first entry into the court, that was it. So
You
from
were a
that-
half Nelson, not a full Nelson.
And Malat, then I was met with another person, Malat, who told me, তোর ব্যান্ডটা লুজ আছে আমি একটু বেঁধে দেবো
So Pratham Chatterjee,
no
who is that?
just Shubhraman Mukherjee Malat, those I will discuss later.
Fight cable.
So Malat, that was my first day and I entered courtroom Malat 6 Malat Justice Nurianan Chaudhary. So I said Malat, I asked for an adjournment. I said thank you, and Mr. Ranjan Rai was on the other side. He said great fool. And I still I know whether I was called a fool or not. So Malat, may I just come back, Malat? So Malat, these are my submissions with regard to this. And
Very well.
and Malat, the other point is, Malat, your lordships, I don't need to show judgments, but your lordship will not find any reasoning in this judgment.
Even if otherwise we are against you on that.
Malat,
and
there is no reasoning. No reasoning, and I say
Judgment 10 paragraph খালি record.
mostly Malat is dependent on Malat, the division bench having confirmed the passing of an interim order. That has played a major role, I must say.
No, but no prima facie case. No, the parameters of Order 39 have also not been.
Because there's no pleading, Malat, how will it be? I might ask myself. Malat, it's just not just saying, Malat, it's not a lip service, Malat, with humility, I say.
Let us hear Mr. Thapar.
Malat, may I be excused, Malat, for some time? Malat?
May you?
May I Malat, leave, Malat, my junior is here.
Depending on which court you are going to.
Malat.
Leave is conditional. No, no, Mr. Thapar, please.
But after this, I really, Malat, if he shows judgments, I will, Malat, obviously.
You cannot put him to terms. He may feel suddenly that I won't show judge.
I'm in very good hands.
So he has that option.
I'm in very good hands, Malat. I always consider him as my senior. Malat.
We also consider him to be a senior.
I'm so grateful, Malat.
Mr. Datta is waiting for you
Yes.
to. Yes. Yes, Mr. Datta. Prima facie, there appears to be justification in the difference of scope in a suit, regular suit, and an original summons. So you can start from there.
Millard, I'll start from what was the issue. Millard, kindly come straight to page 72. This is a portion of the trustee. Interpretation of which, Millard, is an issue in this proceedings. Kindly come to 72(2), which starts with Schedule D, Millard, 1 and 2. Subject to what has been stated above, in case of any vacancy occurring in the office of the trusteeship by death or retirement, without making any appointment in terms of this presence, or in case of any vacancy on account of removal of any of the trustees for the time being on account of unfitness or incapacity, the surviving and the continuing trustee or trustees for the time being, as the case may be, of the said trust estate be entitled to appoint a new trustee in place of the state of the trustee so dying, kindly Millard mark the word dying, or retiring without making any appointment or is being removed. If, however, the sole trustee dies without making any appointment in terms of this presence, or becomes unfit or incapable of acting or such, or is removed, then in that event his nearest male lineal descendant or the nearest male lineal descendants, if there be more than one, failing which lineal descendant or descendants, his nearest heir or the nearest heirs, if there be more than one, will become the trustee or trustees, as the case may be, of the aforesaid trust. I'm not on Tagore and Tagore for the time being. Question is, does it contemplate appointment of a juristic person or a living person? This is all. And that question, Millard, is at page 33.
Company was appointed as a trustee.
Yes. Kindly, Millard, come to page 32, B and C.
B also, yes.
B and C. This was the issue. So according to us, when we moved the originating summons suit, we showed that prima facie, two companies who are juristic entities were never envisaged by the settler to be trustees. Now the question is, why an interim order? Was it necessary for the court? Whether the court has jurisdiction, I'm coming. Question is whether there was a necessity for the court, whether the court felt that yes, it is necessary. Millard, what had happened is this. It has a little background. The background is this, Millard. So far as Millard, and I'll come to this. So far as Millard, the settler is concerned, the settler and his brother Millard made this trust. Thereafter, Millard, it belongs to a Mitakshara family. Now, Millard, once Millard, the 2005 amendment came, Millard, the female heirs also came in. Now, it so happens that so far as this surviving trustee is concerned, he had made a will. In that will, Millard, he has expressly debarred the mother of the director of the company from inheriting any property in so far as his properties are concerned. There is a will. The next day, Millard, or before the will could be probate, Millard, there is also a revocation of that will. After the revocation, there is a letters of administration.
Revocation the next day means?
Next day, Millard, before the will, before this Millard gentleman, the testator died, Millard, there was a revocation. Will was made.
He himself executed another deed.
Yes.
Neither of them were registered, or both of them were registered.
Both of them were registered. Both of them were registered. I will show, if not necessary at the trial, if necessary, Millard, of this, Millard, that there is a chain. The chain is, Millard, there is a common line of advocates are king. Now, thereafter, Millard, this person who was expressly debarred, Millard, so the will was not there, he comes and applies before the court seeking a letters of administration of the entire estate. He passes away. Now his son is there.
He or she?
She passes away, and now the son and the daughter-in-law, daughter-in-law and brother Millard are now in control of what the testator had expressly said should not go.
But if it's Mitakshara, they also have a right.
No, Millard, the thing is this, Millard, if it is Mitakshara, it will only be restricted to his only self-acquired properties.
Yes.
Not the properties inherited. And Millard, once this letter of administration was get, this letter of administration completely suppresses the fact that there are other legal heirs. Completely suppresses the fact. So we filed an application for letter revocation, and that application was heard, concluded, and that is judgment is awaited. Now, so far as this is concerned, the allegation which Millard, your Lordship found in that originating summons suit, your Lordship, due my learned friend's attention to paragraph 19 at page 36.
Yes.
Or Millard, paragraph 18, if I may start. 17 take a poor Millard, 17. The plaintiffs state, I'm sorry, Millard. The plaintiffs state that the majority shareholding in the Wadhwa Endowment Management Limited, that is one of the trustees, and Jerambai Management Services Limited Limited, as held by Damodar Das Wadhwa, holding 98.975 shareholding. So these two companies, the testator had 98% shareholding, complete control. Damodar Das Wadhwa was also one of the directors out of the two in the aforesaid companies. Upon the death of Damodar Das Wadhwa and grant of letters of administration in favor of Onushua, one who was expressly excluded, the said shareholding has been transferred in the name of Onushua. After the death of Damodar, son of Onushua, being Nirmal, was appointed as one of the directors of the said company, and after grant of
It was
letters,
expressly excluded in the will,
yes,
which was revoked.
and that was suppressed.
Your stand is that the will was revoked.
No.
So can you
Millard,
at the
what
same time
No, it's not my
rely
stand.
on
No, I'm not
hard
on that.
exclusion?
During the pendency, when the letters of administration was filed, there was an express suppress, or not, I should say express, there was a complete suppression of the fact that there was a will.
Oh, yes. This he said without will.
Yes.
Right.
When we filed the letters of administration, we also did not know there was a will. When Miller affidavits were being exchanged, then also we did not know.
In your case, you did not know, and in their case, it's suppression.
Of course, Miller, when we made searches, we came to know that there was a will and revocation. And we could find an underlying chain, which Miller, we did not go to that extent because there's a question of evidence of juniors in.
Your argument, Mr.
I'm-
That Anuswa Pujari was excluded does not have any meaning, because as per your client also, it was revoked. That will was revoked.
No, Miller registered will.
Unless you want to go to some other court, please take
No,
a
no, no.
seat.
Miller
No,
registered.
please take a
Very-
seat.
Miller, the question is, before the letters of administration court, my argument was that this, so far as this will is revoked, is something which he need to be brought to the notice of the court. Whether it will have any relevance or not, it's for the court to decide. You cannot decide. You bring it to the notice of the court. The court may not give you letters of administration, may give it to somebody else.
Anuswa's exclusion is not
But
there.
that is not an issue over here. What I'm on is that therefore Miller, Anuswa Pujara and Nirmal Pujara are also appointed as director of the companies. Documented just after that, Miller, they took control of these companies. Thereafter, Miller, my apprehension, the plaintiffs, Wadhwa Endowment Management and Jerambai Private Limited,
Leadership is not crucial here. Shareholding in any event devolves.
Miller, the shareholding devolves on
Yes.
the basis of the letters of administration, not otherwise.
All right.
Then it will go to,
No, otherwise.
otherwise it will go to all the legal heirs.
Yes.
Which Miller, these are not to the own exclusive.
Oh, right.
So if the letters of administration goes and the court, if recognizes the fact that
So they
no,
deprive the other.
yes.
question.
So Miller, this was the question that was framed in the originating summons suit. Whether these two companies, Miller, what is happening is this, Miller. Therefore, Miller, so long I remain a shareholder, I remain in control of the trust. My legal heirs will. So for perpetuity, you have taken over a trust, and Miller, through the trust, Miller, you are controlling the estate of the deceased. So this is what is the long and short of this matter. And in the process, by setting up these two companies, you are depriving the other persons who otherwise have a right. Now the question is whether this question can be decided in an originating summons suit. Now, Miller, your lordship has noticed
Letters of administration was obtained by Nirmal.
letters of administration was Anuswa. And-
Anuswa herself.
Yeah. And the moment thereafter she died, and
Okay,
the son continued, and thereafter. Now, Miller, one thing I just like to, Miller, say before I go into this issue, your lordship will find that in chapter 13 is just one of the modes under the original side rules for approaching a court.
Yes.
It can be by way of judge's summons. It can be by way of master summons. It can be by way of originating summons. These are the 3 or 4 modes of summons.
Yes.
It does not, with respect, does not say that while you are exercising originating summons, the operation of other statutes do not apply. Meaning to say, Miller, if I am raising a question of trust, the Trust Act, depending on the nature of the trust, the duties and obligations of the trustees will be applied. If it is a question of interpretation of a will, then the Succession Act will apply. If it is a question of any other law, mortgage, then the Transfer of Property Act will apply. So the basic civil law is to be applied by the court for the purpose of duty. It's the manner which, Miller, in this case is a summary manner. Now, my learned friend has only showed to your lordship, Miller, one aspect. There are 3 aspects, 3 group of persons who can come. My learned friend has shown to your lordship, Miller, rule 1.
Yes. Yes.
The executors or administrators of a deceased person or any of them, and the trustees under any instrument or any of them, 2, any person claiming to be interested in the relief sought as creditor, legatee, heir, or legal representative, or as beneficiary under the trusts of any instrument, or as claiming by transfer or otherwise under any such creditor or other person as aforesaid, or the surety of an executor or administrator may, as of courts, may take out, as of courts, an originating summons returnable before the judge sitting in for relief of the nature or kind following. So, my lord, it entitles a relief.
But that has to be read, the entire sentence has to be read as a
I'm coming. Lord, relief, as may be by summons be specified, and the circumstances of the case may require, that is to say, the determination without administration of the estate of the trust of any of the following questions or matters. So, court is entitled to grant me a relief. Relief will be based on determination without administration of any of the questions hereunder. Kindly come straight to G. So, beloved, determination of any question arising in administration of the estate or trust. And my question is whether two juristic persons can administer this trust or not.
But the sentence, I mean, we can't gather the meaning of the complete sentence. For such relief of the nature or kind following as may by summons be specified, and the circumstances may require, the determination without an administration, that ultimately qualifies may take out an originating summons. So may take out an original, as of course, an originating summons for such relief
Yes.
as the circumstances may require, and in the summons specified, the
Let-
determination without an administration of any of the following questions or matters. So
Yes.
aren't the questions, determination of the questions, the reliefs?
My lord, the determination of the question would be the relief. Administration, it's my lord.
Can there be any other relief than the determination of the questions in an originating summons?
Yes. That is.
Then why should we? What is the distinction between a suit, regular suit,
It
and
is not. It is a proper suit. I'll show you, lordship. There's a question of taking evidence also.
subsequently, but only for the purpose of determination of these questions
For determination of questions, if
and passing directions?
and for that, my lord, the court can also alter the summons, amend the summons,
Yes.
modify the relief,
Yes.
and take evidence also.
Yes.
And the ultimate that would be passed, my lord, is a drawn-up decree.
Hmm.
But there is a little this decree.
Gray area is there.
No, this decree, my lord, is being sorted out. My lord. The decree, my lord, per se, which will be drawn up, my lord, would be only a declaratory.
Has to be on
Nothing
the
more than that.
on the questions.
On the question. So
Then
here
you cannot convert an originating summons proceedings to a regular suit.
my lord,
Unless there's a regular suit, how can you get an interim order? I mean, there is no scope of
no, interim order, I'm coming.
suit order 39 rule 1
Interim order, I'm coming. Interim order, I'm coming. I'm only on the scope of originating summons. So originating summons suit, my lord, allows me, and so far as my case is concerned, according to me, subject to what your lordship feels, my lord, a question is there.
A suit has to come within the contemplation of section 9, regular suit before a civil court. Section 9 of the Code of Civil Procedure. This originating summons, the entire proceedings does not have any trappings of a suit. It is centered around the determination of these questions. And that is the only relief which you can
And
seek.
the centering upon the determination
Other
of,
reliefs, there is no scope
my lord, there is, my lord,
within chapter 13.
my lord, there is, as I told you, lordship, my lord, this
Chapter
is,
13 is an ecosystem. It's not only a governing procedure regarding the summons of a regular suit. If it was, we could have understood. Yes, you are absolutely right, Mr. Dutt. No scope. If the originating summons was like order 5 or was a subchapter in a suit, then it would be only a mode of summons. Yes. But here originating summons, chapter 13 is an independent proceeding,
yes,
irrespective of and independent of a suit. It's not a
Yes.
suit. It's an entire ecosystem of a proceeding. So
yes.
it's self-sufficient. It's a complete code in itself.
It may not be, but yes, let's take it that
Code
the
in the sense
process-
that yes,
the procedure is in a code in itself.
procedure at
procedure,
least, yes. So therefore, this is not merely the procedure of a regular suit, but it is the proceeding. It is the substitute. You cannot substitute this for a suit, for a regular suit, and ask for an interim relief without going up to the stage of section, Rule 17.
No, I can, Millard. I can. I'll show you,
Yes.
Lordship. I'll show you, Lordship. So first, Millard, whether that order can be passed. One is, Millard, the final relief, which is Lordship is looking at one. Final relief. Relief of the nature A to G, and I'm in G. Kindly, Millard, now come to Rule 2.
Yes.
Any of the persons named in the last preceding rule may, in like manner, apply for and obtain an order for B, the administration of the trust. Relief is determination of any question arising in administration of the trust. Administration of the estate of the deceased is one. Administration of the trust is one. Discharge of an executor, administrator, or surety, and refund of security deposit, if any. Similarly, it contemplates also an order being passed pending a relief. Has to be. It is like saying, Millard, may I come back?
Oh, yes.
So, my lord, it contemplates in case of administration passing of orders. Now, my lord, there are other categories of proceedings also which can be done under the originating summons suit. But before I go to that, kindly come to rule 3.
Yes.
In case of the persons to be served with summons under the last two preceding rules, in the first instance shall be the following. That is to say, in the first instance. That is to say, now let us take A. For determination of any question under subsection G, then I am on G of rule 1, the person or persons whose rights or interests are sought to be affected. So, my lord, it does not contemplate a non-contentious situation. It contemplates a contentious situation. So, there can be contentions and contentious issues can be decided.
Yes, simply by determination of the question, some contentious issue may be decided.
Yes. No, my lord, I was
That does not necessarily
My
mean that
learned
reliefs
friends-
are to be given.
no. My learned friend's thrust of it is only an opinion which the court gives.
Ah.
It's not that.
No, at the end of the day, it's a determination of a question, which is an opinion of the court, has the effect of a decree,
Yes.
but it
And-
may be contentious. That opinion itself, that the
That
opinion
opinion
sought.
has to be, my lord.
Yes.
So, my lord, no, I was that. Now, my lord, the other group, my lord, which may not be interested, but just, my lord, since your lordship is on the scope of it, is, my lord, a vendor can also come. Rule 4.
But that is not.
I'm just giving you
German.
how large the scope is. It's not rule
Yes,
1.
yes, these people can come when these questions arise.
Yes.
Creditor, debtor.
No, for determination of question arising out of breach of contract also.
Ah.
Rule 4.
All right.
Rule 6 also, my lord, mortgage or mortgagee can also come. So, my
So
lord,
these do not help you in any way.
no, I'm not asking
Whatever
for
may be
any
the
help.
sort of people who may come, whatever may be the nature of the dispute, but what is the scope of determination in an originating summons?
Yes,
Whether regular, like, can a
Okay.
regular decree be passed?
yes, it can be.
Like a suit?
Yes.
Otherwise, there would not be any scope of providing that the orders, on the orders, decree would be drawn up. It's not a regular decree which is being passed.
My lord, I'll show your lordship. My lord,
This is not a civil adjudication at all.
My lord, it is.
Centers around determination.
My lord, kindly, my lord, bear with me for some moment, my lord.
Yes.
Bear with me, my lord. I know, my lord, your lordship is has done suits throughout your life. My lord, why not a suit? Why an originating summons? That's why, my lord,
No,
that-
that's yes. Obviously,
is
we
what
put
is
that
said.
question to you also. I mean,
Yes. Now, why not a suit and not a originating summons?
yes.
Is, my lord, after, my lord, the persons interested come, my lord, they
Mhm.
file their affidavit.
Right.
And they file their evidence. I am not the entire appearance, all this process is there. Then 14, it is marked as a suit.
Yes.
The affidavits were accepted shall be filed and numbered as an ordinary suit. As entered in the register of suits, but shall, after the serial number, the letter OA shall be placed to distinguish it from plains in ordinary suits. Yes. That's what I'm showing you, Miller. Then I'll come to 17. Enter appearance, this, that, no appearance. No appearance. And then 17. On the hearing of the summons,
Yes.
where the parties thereto do not agree to the correctness of the facts set forth in the affidavit, the judge may order the summons to be supported by such evidence as he may think necessary, and may give directions as he may think just for trial of any questions arising thereon. So, Miller, a trial is contemplated. The judge may make amendment in the affidavit and summons as may seem to him to be necessary to make them accord with the existing state of facts, so as properly to raise questions in the issue between the parties. So, till such time, up till here, my lord, it's a summary procedure, but the procedure of the suit is being
And
followed.
21 contemplates execution also.
Yes, I was coming.
21 is very crucial. We have seen 21 when Mr. Rai was arguing.
Yes. Then,
Yes.
what is the discretion left with the court?
Hmm.
The judge hearing and originating summons may, where he thinks fit, adjourn the same into court for hearing and argument, and where it appears to him that the matter in respect of which relief is sought cannot be disposed of in a summary manner, may refuse to pass an order on the summons, may dismiss the same, and refer the parties to a suit in the ordinary course, and in such case may make such order as cause already incurred may seem determined. Similar, three options are left with the discretion of the court. One is he will admit it. Second, he may say that I can decide it on the facts given before me. He may read further evidence. Other persons can be summoned. Other persons may come and give evidence. And thereafter, if he feels that this cannot be decided in a summary manner, Millard, then he may refer the parties to suit. Here, Millard, the court has expressed this view that the originating summons has to be decided, and therefore he is asked direction of service of summons on the defendant. Thereafter, Millard, 20. Order made on originating summons to be drawn up as a decree of court, where the judge is of the opinion that the matter is fit to be dealt with on an originating summons, he may pronounce such judgment as the nature of the case shall require. And any order made by him shall be drawn up by the register as a decree of the court, provided where the judge dismisses the summons under Rule 18, it shall be sufficient for him to sign an order to that effect, which shall be filed in the proceedings. So it contemplates a decree, and thereafter is very important. The judge may give any special directions touching the carriage or execution of such decree, or the service thereof, persons, not parties, as they may think fit. So, Millard, it can also affect rights of parties who may not be there, the party. Now, Millard, this entire code, if your lordship borrow in lordship language, it's a code. Then, Millard, it contemplates adjudication of a particular dispute regarding the reliefs, particular nature of reliefs in 1, 2, 4, 5, and 7. Those are the 5 persons who can come, and court can pass a decree and an executable one.
1 and 2, Mr. Dutt,
My lord.
the questions which are coming to us, we were just asking you.
My lord.
1 and 2 operate in separate fields. In the sense, apparently, subject to you correcting us. Apparently, because 1 contemplates determination of questions on these topics. Reliefs word is also used, but that is used in conjunction with determination of following questions or matters. 2, on the other hand, says any of the persons named in the last preceding rule may, in like manner, apply for and obtain an order.
Yes.
So there's subtle distinction between the two.
Yes,
Determination
there
of a
is.
question and
There is
order may be for this.
administration.
Now, in your originating summons, there is no order sought even, no relief sought even. So you don't come under rule 2.
Not necessary. Not
But it's not court may pass an order. It's apply for and obtain an order. It's the duty is cast upon the party. You have to apply for that order and obtain.
Sure.
But you have not applied for any of any of these.
No, with respect, my lord, I am to frame it, but what I am drawn is this. If your lordship feels that the court had jurisdiction to entertain this originating summons because there are questions involved, and the court has, is the court bereft of the power under the originating summons to pass an order to protect the subject matter, which is the substance over here?
Yes.
Millard, the first question was the question which I asked myself, the question which fell from your lordship. Is there a bar? I don't see
We don't
any
find
bar.
any bar.
There is no bar.
No.
On the contrary, Millard, it appears to me that the court has the power not only to adjudicate and pass orders, it can pass directions, and it can pass directions on particular group of persons also who may not be there also.
At the ad interim stage, Mr.
Yes,
Datta,
at this ad interim stage.
no, we are saying what we mean to say, interlocutory orders can be passed in the aid of the final relief sought in whatever proceeding, suit, other proceeding. So it has to be in the aid of the final relief. If the final relief is merely determination of certain questions XYZ, then where is the scope of any ad interim order in aid of such reliefs? If the aid is determination of the questions.
So what was the question? Whether these two persons can
Now, whether any injunction can be granted or not, If those are questions, but that has been deprecated in State Bank itself, which was cited by you.
But that is also a question over here also.
Because there it is recorded by the court that pure question of law, unless it's a pure question of law, these questions of fact which require these, I mean, going into questions of fact and not evidence, yes, evidence in support of the main facts, but we don't recollect the, I don't recollect the
Let us-
expression
let us-
used right now. It was used, I mean, the questions which cannot be, question of fact, it was said in State Bank. In the event there being para 31 of State Bank, in the event there being a question of fact, matter ought not to be dealt with by way of an originating summons. And also, para 33 end.
Milord, yes, Milord, this judgment, Milord, with
Yes.
respect,
Yes.
does not lay down the proposition that an interim order cannot be passed. It does not.
No.
It has kept the question open.
Yes.
It has kept the question.
Absolutely.
So, Milord, your lordship.
But this was relied on by the learned judge
Milord,
to
it was
say that-
relied upon by the learned judge only for the purpose of showing that this is
on the basis of the arguments of the learned counsel who was there.
possible. It is possible. Interim order is possible. And the learned judge has held that interim order is possible and is passed.
Let us see whether that has been headed.
Kindly come to the order.
Para 6, Mr. Such and such submits that the,
Para
yes,
4.
no, the reliance is placed in para 6. Mr.
On the judgment,
On the judgment, yes,
yes.
wherein the Honorable Single Judge has granted the interim order in the originating summons suit, which was duly confirmed. It's just the reverse. It was set aside in appeal.
No. What was set aside in appeal was
On a
because
different
the
ground.
originating summons itself.
Yes, but therefore this is not correct, which was duly confirmed by the Honorable Division Bench.
That is not so.
So that is the premise. And Shekhar Go, Shamuli Go, it's only stated has also passed an interim order. No adjudication was. So these cannot be authorities for this.
Milord,
You are fair enough.
For the-
You pose the question yourself that whether this can be granted.
I'm
That
only-
shows your fairness only. But
Milord, it's not a question of my fairness, Milord, because the judgment which is there, I am officer of court, Milord, I cannot
at an
come and
expert-
say that, look, the court has decided. I am saying that the court has not decided it. Because it expressly says, if your lordship sees the last line of that judgment.
where is the reason for granting this injunction? Or
It's from the order itself, Milord. Milord, with respect, Milord, even for the time being, Milord, kindly visualize this situation. Kindly visualize this situation. My contention would be the reason for passing an interim order would be from my application. My application, I have read before your lordship, Milord, I have expressed an apprehension that the trust is used as a conduit for the purpose of siphoning of the funds. That's an express allegation. What has the judge said? The judge has only said this.
para 8 to 10.
Para 8 to consider, we find that the plaintiff apprehends the companies will alienate the property and an application is pending for revocation of the will. If the present suit seeks answers in the opinion. Considering that the plaintiff has made out a prima facie case and the balance of convenience in favor of the plaintiff.
Considering the above, what is there above?
The above
You
is, Milord,
apprehend that
no,
without any basis.
paragraph 4 onwards, Milord. Kindly read paragraph 4 with respect, Milord.
No, that is your apprehension. Plaintiff apprehends that the said companies will alienate the property and an application is pending for revocation of the will.
No, paragraph 4.
Reason is not paragraph 4.
No. So therefore, when the learned judge
Paragraph
says-
4 is a narration of your argument.
Yes, considering the above, the plaintiff has, so the allegation.
You have expressed an apprehension. What
No,
is the
Milord,
basis of grant of injunction?
The thing is this, Milord. I have expressed an apprehension.
That is sufficient.
No, that has been
Then
recorded.
nobody will file a suit. Everybody will go and file an originating summons and get an order. I express my apprehension and
No,
get the
kindly-
order.
Kindly not take it. There are two ways, Milord. Milord, your lordship goes to the extent of saying that I have considered this submission and therefore on the basis of these materials I come. It is also possible that the plaintiff's submission at this stage is recorded and the court feels that they are bona fide.
Let us see that
Very well.
from
Mr.
paragraph 9.
Ghosh submits that the majority shareholding in Wadwa
No, that is not the reason. In the reasoning part, we want to see that only.
Milord, the
That court finds that yes, you have expressed an apprehension, and I feel that that should be given even there.
with
9
respect-
says this
Milord,
court
don't
finds.
With respect, don't read that last paragraph bereft of the first. The order is in its entirety.
No. Sorry, Mr. Dutt, but we have to, because that's a narrative. The first few paragraphs are the arguments of counsel.
Very well.
We
Milord,
cannot go, that is not a part of the reasoning of
very
the
well, then
judgment.
start from 8.
8.
Start from 8. Considering the submissions made by the counsel, which is 4 to 6.
Considered,
Considered
peruse material on
and
record.
peruse the materials on record.
Yes.
And the judgment relied on by the plaintiffs. 3 things.
Let us see the
Submission.
reasoning now.
The court finds that 2 companies have been made as trustees of the defendant number 1 trust. Right? This is a question which I have raised. It cannot be. The plaintiff apprehends that the said companies will alienate the property and an application is pending for revocation of the will. In the present suit, the plaintiff seeks answers and opinion of this court. Considering the above, the plaintiff has made out the prima facie case and the balance of convenience is in favor of the plaintiff. Accordingly,
Your apprehension is the prima facie case.
he's found it that this apprehension is
The
supported.
plaintiff apprehends, he has not found it.
Yes, no, Millard, this.
The plaintiff apprehends that the said companies will alienate the property and an application is pending for revocation.
Yes.
In the present suit, the plaintiff seeks answer and opinion from this court.
So
Considering that, the above,
Millard,
plaintiff has made out a prima facie case.
with respect, Millard, this plaintiff apprehends that the companies will alienate the property and an application is pending for revocation of the will has to be read with the court saying that I have considered the submissions of the plaintiff, I have perused the materials on record and the judgment relied.
So those are brought into the fold of this consideration.
With respect.
All right.
With respect. Millard, it may not be, Millard, as I said,
No.
it may not be.
All we in record appeal, we won't go into the, I mean, what should have been done, what no.
Yes.
Definitely. One view is possible, we don't interfere.
So now, accordingly, the restraint, this is very important because that would be my next point. Accordingly, defendants are restrained from transferring, alienating, dealing, selling, encumbering, or parting with any of the assets, including the accounts lying in the bank, amounts lying in the bank account and fixed deposits till 22nd May 2005. Millard, this injunction cannot be challenged by my learned friend.
Why do you say that?
Because, my lord, if your lordship sees the trust property, trust deed, this is a devottor.
They are trustees, the companies.
They are not trustees. The company is the trustee.
Companies are before us.
Company is yes. The
That
company
is what you said.
yes. The companies are before us, but the trustees do not have the power under the Trust Act deal with anything. The income of the property. Now, Millard, comes the.
We said that the appellants are the defendants, so-called defendants. They have been restrained. They have every right to come up in appeal.
With
If
respect,
they have been restrained,
they have been restrained of doing something which they don't.
I
have
am
the right.
restrained. I don't have a locus to come up in
No,
appeal.
I'm not on that. Not kindly. You have a right to come up in appeal,
Yes.
but the injunction that has been passed cannot affect you.
Then very well, we'll vacate the injunction. It cannot affect the defend. If it cannot affect the defendants have been restrained. We'll say it's a meaningless injunction then.
No, Millard, you're looking at, your lordship is looking at.
Defendants have been restrained. You are saying defendants won't be affected, Mr. Dutt.
Millard, I could not probably express myself. Give me 2 minutes, Millard. The trust deed is for benefit of 5 deities. All the properties are vested with the deities.
With the
Deities.
deities, yes.
They are all Devottar properties. My learned friends' clients who are trustees, Millard, namely the 2 companies, have their rights and powers designated under the trust deed.
Absolutely.
Under the trust deed, all they are supposed to do is collect the income from the properties.
They cannot transfer, you say.
And put it in the bank account of the 5 deities.
That is an argument on merits. Because if you say that they can always challenge because you have got an injunction against them.
So, Millard,
and if you say that they don't have the power, then there was no necessity of an injunction.
Not the question of power, your lordship is that I didn't mean in that way. What I meant is this, Millard. If my learned friend has come before your lordship saying, he has raised 3 points. Scope of originating summons, order, not service this.
Reason also, no reason.
Yeah, no reason. But he has not told your lordship, or not even he has argued ever, that look, this right of mine under the trust deed has been taken away without hearing.
With to respect to your submission, Mr. Dutt, it's for you to say, satisfy the court on the reverse. One person has been injuncted from doing whatever. He has always, his rights are definitely affected. If you say, if that argument is taken to its logical conclusion, your argument, then there would be no necessity of an injunction at all.
With respect, my lord, if I had been the appellant, the first effort that I would make to show is that this injunction interferes with the right given to me either under the trust deed or otherwise. And look here that the judge has done it without any reason or did not consider this. Has your lordship been addressed on that issue at all?
They cannot operate the bank accounts. Otherwise, how can they administer the trust?
Kindly sit. I am obliged.
But Mr. Dutt will have to go into the merits on that.
Cannot deal with
That we probably can't.
But the thing is this, my
It
lord,
has to be evident from the order itself, the reason.
my lord,
The appellate court won't look into the reasons.
the material which the court has considered,
Yes, consider the submissions and the materials.
the material is
Will
the
you please show us that part of the trust deed you are showing us?
Yes, my lord.
Yes.
Lord, your lordship will find that the trust deed starts from, I'm sorry, my lord, pata de, page 59.
Yes.
Kindly, my lord, come to page 63 straight away.
Yes.
The settler doth hereby grant, transfer, convey, and my lord, I'm starting with the operate now. This indenture witnesses. I'm starting from that, my lord. That for the affecting the said desire and in consider the desire is, my lord. I'm sorry, I should have.
No.
Hello?
That's not what page 63. Internal page 5.
Yes.
Does not start with
My lord, no, it doesn't start, my lord. It's 3 lines from the bottom.
the settler doth hereby grant,
Yes.
transfer,
Lordship
convey,
gives
and
the-
deliver.
Yes.
That you have found.
My lord, Lordship gives you a
To
more.
5,000.
No,
Just before 5,000.
No, there is a these deities are somewhere there. Lordship gives me a moment.
Yes.
Yes. No, my lord, I start from there. That for the affecting the said desire in consideration the premise and for other good causes consideration moving, the settler doth hereby grant, transfer, convey, and deliver unto the trustees all that the said sum of 5,000 and the full benefits and advantage thereof, and also right, title, and interest claiming demand whatsoever at law and in equity in settler of the settler and or paid cash money such as upon trust for the purpose hereinafter declared concerning the same. That is to say, upon trust, to hold the same and use the same for the objects fully and purposely mentioned in Schedule B. Schedule B is at page 64. The objects of the trust will at the bottom. Schedule B.
Yes.
The trustees, if there be one or trustees and there be more than one for the time being, the trust estate will hold in equal share and or properties of the trust properties and rents, issues and profits thereof for and in the account of and not the Sheva Puja and recurring periodical ceremonies of each of the herein before mentioned deities, namely Sri Kali Jiu, Sri Shankar Jiu, Sri Radha Jiu, Sri Sham Jiu, respectively. Such trustee or trustees for the time being of the said trust estate will realize the rents, issues, and profits and will credit such rents, issues, and profits of the said trust estate in the name of each of the deities hereinafter mentioned in equal share and or proportionates and or proportions. Similarly, all expenses and disbursements which may be incurred by such trustee or trustees for the time being of the trust estate in and in the course of management of the trust except the expenses and Seva Puja for the current and periodical ceremonies of the trust deities respectively will be debited in the respective accounts of each of the said deities in equal proportions. The Seva Puja and the periodical ceremonies of the deities respectively will be performed out of the net income of the said trust estate, which may be held in the account of each of their respective duties, deities, expenses of the Seva Puja and the recurrent and periodical worship of each of the deities will be debited in the account of the particular deity for whom expenses would be incurred, provided that notwithstanding anything to the contrary herein contained, the trustee or trustees for the time being estate will not spend more than 70% of the net annual income of any of the said deities for the Seva Puja and in recurring and the periodical ceremonies of the particular deity. This is all the rights they have. This is the object.
Sell or do anything have to come in.
Why shouldn't the court direct it to be relegated to a regular suit? We don't still understand. How can this come within the scope of you are arguing the suit full-fledged? I mean, this is how can this be done by way of an originating summons? There has to be a distinction, Mr. Dutt.
Millard,
You cannot convert an originating summons to
a
a
suit into a originating summons. Your
no. You cannot convert an originating summons into a suit either. The scopes are different.
Millard, that Millard at the final
At the
trial,
originating summons stage, it's not a suit.
at the final
It's marked as a suit. Yes, original suit.
only that Millard, your lordship knows that as seen Millard, if the court finds
Yes, it can.
that this has to be tried as a suit Millard, then it has to
Then
direct-
it has to be relegated to a suit.
so that is to be at the final hearing of the originating.
Exactly. That is precisely what we're saying. This is a prelude to a suit. Maybe a prelude to a suit unless it's rejected. The ultimate goal of this originating summons is to decide whether these questions should go to a suit or not. One of the goals. So therefore, you cannot convert the prelude to the epilogue.
But Millard, if the court finds that the trustees cannot, in view of the express.
What you are doing now is arguing the suit.
No, Millard, I'm not arguing. All I'm trying-
Because if that is required, we are trying to say, Mr. that you are fully entitled to do that. But yes, this is the now. If you have to do that, then it shows that this is not within the scope of an originating summons, determining questions which fail for.
for administration.
Suppose if the questions which you frame are whether a decree should be granted in favor of the declaring the right title and interest of the whether a decree should be granted by way of eviction of the defendant, whether a decree of mean profit should be granted. If that is the question formulated,
So Millard, because that
what are your
that is
fifth, sixth questions?
Millard, the court can reject it. The court can reject it.
So therefore, if the court can reject it, if those you cannot do that, then no ad interim order in aid of those reliefs can be granted. The
Millard,
questions are innocuous apparently, whether a company can be a trustee.
yes,
In aid of that, what relief should be granted at interim stage?
Millard, if the court,
Suppose the court says yes, or no, it cannot be.
if the so either it has to say yes or it has to say no. Now the thing is that it will await.
No would be in your favor. I mean, in your favor means
Whatever. I am not on the question.
no. I mean, no would be your best case rather. No, it cannot be.
Millard,
Cannot be. So even then, in aid of
Millard,
that
in
injunction.
in respect, Millard, your lordship has seen that provision where the trustees can be appointed. If there is nobody, the male lenient dissident would be the trustee. Millard, do I need a further explanation for that? That does a juristic person fit into it? There are concepts, Millard, in law, but those are mots, mundis. Those are treated, Millard, as juristic persons under the Hindu religious and charitable endowment.
That's a different concept.
But not a private limited company. I don't need to show more. Now the question is, which I am trying to address, is that so far as this, if this is the power given to a trustee, my learned friend would have apprised and said that, look, my Sheva Puja is stopped.
Difficulty we are facing is, Mr. Dutt, there can be rule 1 of order 30, chapter 13 or rule 2. This is not a rule 2 scenario because you have not asked for these orders. Because under rule 2, similar manner, apply for and obtain an order for this. You have not applied for an order at all. You have asked for determination of questions, so it is governed by 1. Where the scope of the relief is that determination of the question. There is not a single relief or order sought in the application in your originating summons. And Mr. Dutt, what happens is court can pass directions undoubtedly, but that is at the rule 17 stage. Because before that, there is no scope of grant of directions. That is what we are saying. That can only be after affidavits. You ask the question to formulate answer certain questions, you formulate the questions. While doing so, court issues summons to ascertain what? Whether the other side agrees. Yes, these questions are correct or these should be the answers or whatever on those questions. While ascertaining if it is found that no, they don't agree, then court can definitely pass directions, do whatever, pass directions, direct affidavit, evidence, further evidence, and that will have the effect of a decree. But not before that. Because before that, the scope is only determination of the questions.
Millard, I'll put it the other way around.
Yes.
Millard, this injunction
Hmm.
determination of
Yes.
questions involve rights and obligations of parties. These rights and obligations of parties come out in this instant case would be under the Religious and Charitable Endowments Act because it's a devoto.
Hmm.
Now, Millard, contemplate a situation, Millard. I'm just thinking. Contemplate a situation, Millard. I had filed an application under Section 7.
Under section?
7. Because it's a private trust 34, Section 7 Religious Endowments Act.
Yes.
Millard, there are examples galore
Hmm.
that courts, for the purpose, if the court finds that there is a direction, management, administration is necessary, courts have always passed protective orders.
That is precisely our point.
I'm coming to that.
That is
So,
precisely our
At
point.
an interim stage in a Section 7, at an interim stage in a Section 7, the court is not bereft of its power to pass for protection. So far as originating summons suit is concerned, Millard, if I have come before, I have chosen one of the forums. I could have gone under Section 7, I could have filed a suit, I have chosen originating summons, one of the forum. And that forum allows me to raise this issue.
Section 7 seeks a remedy, seeks a relief. Relief by way of directions for management or whatever. That's a relief you are claiming. It's a regular proceeding asking for reliefs, which might be the contemplation situation under Rule 2.
Rule 1 and 2.
Not 1. 1, you are not asking for any relief at all because as per your affidavit also and the originating summons itself, you ask for determination of certain ABC questions. That is the only relief you have sought, which is under Rule 1. And in aid of that, in aid of determination of questions, no directions can be passed. If directions are to be passed, those can only be passed under Rule 17. Before that, there is no scope.
Millard, why not 2, if I may ask myself this question?
This is not under 2 because you have not applied for any order. That is why we are telling you that. Because the language is different. 1 is you ask for such relief, nature of kind, the determination without an administration of the state of the following questions or matters. These questions are the determination, are the reliefs in 1. And in 2, you apply for and obtain an order. There is marked difference between the languages of the two. You have not applied for, no question of obtaining order. You have not applied for these reliefs. If you had, it would come under 2. Then the scope might have been different. You have sought for reliefs, you have sought for orders. But the directions contemplated in Section 17 is by the court suo motu upon ascertaining contest on the determination of the questions.
So, Millard, your Lordship is looking at it from this angle that if a person, a plaintiff, approaches the court under originating summons, he will have to file, if he wants orders, in an originating summons.
We have some dispute with that. It's not a plaintiff who is coming. A plaintiff can only be in a suit. It's a legal fiction which we are creating by saying that
as a suit, therefore I say I'm a
marked as a suit is different from a suit. Otherwise, should not have been provided here that it shall be marked as a suit. By default, it would be marked as a suit.
Yes.
And it would not be provided that the order would have a degree would be drawn up. Otherwise, it will be by default. Order 2, Section 2 of CPC read with Order 20. It would be by default. The very fact that it is being, it's a pseudo suit, you may say, at best. So it's a pseudo plaintiff we are speaking about. If the plaintiff, this, whatever you call, the culmination of this exercise under Rule 1, Mr. That would be the formulation of a question, determination of a question. Which determination, as you perfectly rightly said, would be in the nature of a declaration, which would then become a decree. But then the court would have to relegate the parties to a suit. That then this, if the suit exercise was to be concluded at the originating summons stage, the further relegation to suit is meaningless.
further, no, my lord, if the court finds, my lord, there are three instances
Oh,
in
if dismisses, then
Ye-
all right.
yes, there are three instances.
All right.
It can dismiss it. My lord, it's not that, yes,
No,
there
you
is
may
a-
argue. Yes,
there is an issue to be tried.
understood. Yes.
So, my lord,
Hmm.
therefore, I was trying to understand that if I come before the court, I file an originating summons,
Hmm.
and I raise certain issues, and the court find that these issues can be tried, so the evidence requires to. Now, unless my learned friend shows, agar I have shown to your lordship that the court has a right to pass an order, unless my learned friend shows that no order could have at all been passed, because milord, the court in Buri, milord, would, milord, refrain from stealing jurisdiction from a court unless it is expressly barred. Otherwise, the court has jurisdiction. And the
That
practice.
section 9 cannot be applied here because this is not a section 9 scenario.
I'm not
That is
saying-
what we started with. Because if section 9 was there, you are quoting section 9, in fact. Paraphrasing.
I'm not paraphrasing section 9.
Section 9 is inbuilt in us.
All I'm trying to understand.
Section 9 is inbuilt in us. Yes, section 9.
Milord, I want a very basic question, Milord. All that I've learned all these days is that if the court feels that there is a issue to be tried, it can pass orders, if not even prayed under 151 or
Courts have felt like that and have been penalized time and again for that. Courts felt that we can do it. We can pass whatever order we like, and then they have
that I
been
can show
penalized.
to that
So
extent.
don't
Milord,
don't go by that court may
Yeah.
feel and all these things.
but
Court's feelings are immaterial.
what I'm on is, according to me, subject Milord,
Court has the power.
court has the power.
This concept, Mr. Dutt, has undergone a sea change now. Court has the power. Chartered High Court is, I mean, just below God or the King. These concepts are gone now.
Yes, it's gone.
It's gone.
It's gone.
First tribunalization, then which is, I mean, if legislature feels they're elected, yes, we don't have any qualms.
Milord,
But those concepts are now have undergone a sea change now. We don't have the power to do whatever we want under the sun. I mean,
it has not.
our powers are very circumscribed.
Yes.
And if it's by way of originating summons, this is not a derivation of section 9 because original said rules otherwise regarding a suit is derived from some statute, either the Code of Civil Procedure, the parent provision is the Code of Civil Procedure, or the Commercial Courts Act, or the Arbitration Act, whatever you say.
Milord,
That is governed by the
the
procedure.
original side rules comes first, Milord, thereafter.
Undoubtedly, but in and
The CPC,
yes, original said rules, but original said rules, Mr. Dutt, vis-a-vis a suit is not a complete
that's why
substantive
there is
code.
that provision that in the event there is a conflict,
Conflict, yes.
then original side rules will prevail if the suit is before.
Regarding procedure, regarding
It's all
procedure,
procedural. It's
procedure.
all procedural. And I'm only trying to show to your lordship,
Hmm.
Milord, my learned friend's argument was purely on
We are
procedural.
trying to think what should be the reason for a person to go and file a regular suit and go through the regards of a suit. Then one would file an original side, an originating summons, and get interim order.
There is no trial involved. In this, Milord, there will be no trial involved.
Exactly.
In this case, Milord, is the trustee.
No, under section 17 may give evidence, may give directions. Everything is there.
I could have understood, Milord. My learned friend would have. I have not raised any contentious question regarding any other issue. I have only the trust deed, and the trust deed is an admitted document. My learned friend says I am a trustee.
Now, regarding interplay between 17 and 18, Mr. Dutt, where does the court draw the line? 17 says on the hearing of the summons where parties there to do not agree, judge may order the summons to be supported by evidence and may give such directions as he may think just for the trial of any questions arising thereof. So there is a trial of questions. Judge may make such amendment in the affidavit and etc. And then 18 says the judge. So 17 says judge may direct a trial also. 18 says the judge hearing an originating summons may such and such adjourn, and where it appears to him that the matters in respect of which relief is sought cannot be disposed of in a summary manner, may refuse to pass any order on these summons. May dismiss the same and refer the parties to the suit.
Milord,
So where do we draw the line?
somewhere akin to Milord, somewhere.
Summary suit?
I'm coming.
Summary suit?
Let's
Those
go on
tests.
37.
But those tests are not provided.
Tests are not provided.
We cannot import that.
No, no,
CPC cannot be imported here.
no, not the question. The test is, Millard, importing of that test, Millard, is something, Millard, is not akin to a summary procedure. It's a summary procedure, but Millard, the tests are universal. Now, the universal test is, Millard, let's take like order 37. Why will I file a proper suit when I have ingredients to file an order 37? Because I can go for a summary trial, it's expeditious remedy. Millard, commercial
There are
suits
specific parameters for that.
here also.
37, order 37, commercial court, all the more.
So therefore, Millard, in an order 37 suit, if I can ask for an interim injunction, and the court can pass an injunction restraining the parties.
That's a suit all the same. The procedure is summary, but the
Also,
proceeding is a suit.
So, Millard, what is troubling your lordship?
You ask for reliefs in a suit, Mr. Dutt.
I am
that is-
asking for reliefs.
Not a single prayer portion in your
My lord,
show us from your originating summons. Only you ask for determination of the questions, not under Rule 2.
so that is the relief. Millard, the word under Rule
How
1
can
is-
there be an injunction in aid of a determination of a question?
Millard,
2 we could understand. Apply for and obtain an order for administration of this.
Millard, kindly, Millard, come to this, Millard. কোনটা? F পরে আসছি আগে এইখানটা দেখি Millard, I mean, I trouble your lordship with Rule 1 again, Millard. I have read it up the number of times, Millard, your lordship. For the relief of the nature or kind following. So this is the larger relief.
There is no conjunction between that and the determination. That is the difficulty. The language is, it's not a complete sentence, in fact.
For such relief of the nature or kind following,
So may take out originating summons for such relief of the nature
which is A to
or
G.
kind following and such require the determination without an administration of the estate or trust of any of the following questions or matters.
So if I am to read all of them
Yes,
conjunctly,
then it's the relief of the kind following and then determination without an administration of the trust following questions are then
So-
it's determination of questions of matters which is prefixed by such relief of the nature of kind following.
Right. So G, so if the relief is G,
Nothing else follows than this
No, no,
determination
no,
of
no, no,
question.
with Millard, kindly, if the relief is what I'm seeking is G, determination of questions. This determination would be without administration. So I come here. And for administration,
Precisely. Then if it's administration, then it comes under 2.
no, but
Then you have to
administration is
apply
here
for an
also.
order.
Administration is here also, arising in administration.
Question arising in the administration.
Yes,
Yes.
administration is there.
But without
Two
an
is-
administration of the estate.
2 is an additional prayer, Millard. That is
Yes.
where I come in.
No, the determination without an administration of the estate or trust
No,
of any,
G,
that
the
has to be given-
determination of any question arising in
So that-
administration.
that's prefixed by the determination before A. The determination without and what meaning do you attribute to it? Without an administration of the estate? You
Without,
can answer a question arising in the administration, but you cannot pass an order of administration of the estate.
that is this without an administration of the estate of the trust of the following questions, then Millard,
So
Uh,
therefore, the determination without an administration of the estate, you can determine any question arising in the administration, but you cannot pass
And
an
for
order
the-
of the administration.
and for that,
2.
you have a right to pass an order.
2, not a right to pass an order. 2, the person has to apply for and obtain an order.
Now,
You have not applied for any order in the nature of 2.
কোনটা? E.
You have not applied for any order at all. You have asked only for determination.
Millard, kindly Millard, see 1 E. Directing the executors, administrators, or trustees to file account and vouch to do or not to do the same, or abstain from doing any particular act in
And the
their
payment
possession.
into court is also there in D.
Yes.
D is also there.
Millard, it is.
And you have another thing also in your favor, not only following questions, but or matters. So
Yeah,
that may bring it within your fold.
And not only
Matters
that,
directing the executor.
my lord, I have also asked for that question. I have framed a question to that effect. F and G.
The court can only answer the questions then.
So therefore, in aid of that, it can also pass an order abstaining somebody from doing it.
That direction stage comes only in 17. That is what Mr. Rai is arguing.
Mr. Rai is arguing that. Mr. Rai is arguing.
There is no scope of any direction prior to that.
Where is the bar? If I may ask myself this question, how will I, if I can pass an order, why can't I pass an interim order?
Because the direction is to be passed, Mr. Dutt, only after giving a notice, summons is served and an affidavit is a defense is taken.
Yes.
Only then direction can be passed.
No, Millard.
If you refute, if the other side comes and refutes, only then.
Millard, let's take it, he refutes it. It will fall for determination. The court may refer the parties to suit. Court may say that no, the
No,
trustees
if
cannot.
it's referred to, yes, then.
Court may also say no, juristic persons cannot be.
Hmm.
Now, by the time the court says this,
It will become infructuous.
Millard, Lordship sees this. Lordship sees this. 6 crores of Millard, I don't know that they both.
By this you are meaning who? Which?
Millard, we've been able to lay hands on the balance sheet. Millard, it shows 6 crores of rupees have been lent by this
That is
company
for the
to
perusal of Mr.
its
Ghosh.
sister concern
Yes.
against an interest of only কত? 12, sorry, 12.
The sister concerns have taken out the printouts.
Millard, kindly.
It appears that the sister concerns have
But
taken out
we
the
didn't
printouts.
have it on the when
The balance sheet, we won't go into the balance sheet.
Millard,
That much we are also aware with it.
I was surprised that
You know,
Devottar estate has 6 crores of rupees
Not given, not has, it's given out, advance.
and has gone.
And 1200 rupees.
So this is what Millard I was trying to
Very
say.
well. So we understand that because if the final relief, I mean, that's the final relief then. Even if it's it's directed to be relegated to a suit, then also in the suit you can get that relief. And also if you determine the questions that will have the effect of a decree, then probably in aid of that you can do. Before it is decided at least.
Yes, at least. And Millard, as I said, Millard,
Yes.
I have shown the trust.
Juristic entity.
Yes, it's
So
Devottar.
prima facie, that is on prima facie.
But I will go a step further. I was carrying judgment that it's a duty of the court because the deity is a perpetual minor.
Yes.
So court retains jurisdiction to and I was surprised. And what is his allegation? Why is he aggrieved? The paragraph to the
Why is he aggrieved? Must be in the memo.
no. What paragraph? No. Why? How? What is page 40? Kindly see paragraph 44. Where does he get this? Right. Your petitioner being a trust. Petitioner being a trust and 2 companies have regular expenses which are required to be made.
No, one of the petitioners is a trust. 2 is a trust.
The petitioners.
Oh,
being-
trust being a company.
Yes.
They say that. We are not
Have
bothered with
regular
that.
expenses and are required to meet daily expenses. Expenses like salaries of employees, bonus, statutory charges,
They have been restrained from operating the accounts.
and other charges which are required to be made from.
Yes, parting with any of the assets, including the amounts lying in the bank account.
Yes.
That may affect them. That may affect the regular operations of the trusters.
Permit that daily Sheva Puja, keep them separate accounts, modify the injunction to that effect.
Apart from daily Shiva Puja, they also can acquire property under the trust which you are. The next few paragraphs.
If they
So why can't it?
maintain accounts so far as this daily Sheva, daily Puja is concerned.
So they can operate the accounts but maintain accounts.
And no fixed deposit, no.
My lord,
Is the Ghosh who's agree to that?
no, or is it that no fixed deposit, no, the fixed asset should not be.
Fixed assets, no, not fixed assets. Regarding the amounts lying in the bank, the money.
Millard, thing is this, Millard, these major transactions that are happening, Millard, Millard, what will a devota have, Millard?
Only Nokul
In view of just, some other judgment, Nokuldana and the trustees will write.
Devota Janmo. Remember that a stone was turned into.
Yes.
So Devota Janmo is for the purpose of human exploitation, if I may say.
Trust should be.
The trust, I am only on the injunction, my lord. If they say that I am having difficulty in Shiva Puja or performing the daily puja or anything, is not even charity they do, then my lord, I had no problems with that. But not dealing with 6 crores coming in and then going out in the accounts of the trust estate,
For
my lord,
1200 rupees interest.
those should be protected.
Yearly.
Those would be my sir.
Yes.
My lord will not take any judicial notice of, my lord, submissions which are not borne out of records. The 6 crores and odd was not before the trial judge. Secondly, my lord, my lord will see the manner and mode in which this order was
But
obtained.
it is your balance sheet.
The originating
No,
summons,
we're
my
not
lord,
going. We told him we were not going. And he knows we are we're not.
It is his balance
He doesn't know it's his balance sheet.
I'll give a copy to him.
my lord. My
More
lord,
importantly, we don't know it's his balance sheet.
no, my lord will see one
No,
thing-
forget that chapter. Yes, we are not looking into anything which
balance
is
sheet. Now,
at
my
this stage at least. Yes.
Now, my lord will see at page number 22 of my stay application when this originating summons was taken out. In the copy served upon us, the date was not mentioned, but it was mentioned February, 2025.
Hmm.
This was ultimately in the nature of an ex parte ad interim order. Kindly sees February 2025, this originating summons was taken out, at least that is what appears from my copy served upon me. And my lord will see that it was moved without notice, my lord, on August 1st, 2025. Ultimately, even if they are trying to sustain this order, it would be in the nature of an ex parte ad interim order. After 6 months from taking out this originating summons, my lord, this application was moved.
Hmm.
And my lord, the affidavit in support of the originating summons, my lord, was also on 29th of February 2025. So, my lord, originating summons taken out in February, affidavit affirmed in February, they wait till August.
You want to go somewhere?
No. Just I'll address his and also assist.
No
him.
reply to reply.
No. Just the fact that he's saying it was in February. Matter was running in the list of the Honorable Single Judge of this court. It was released on 14th May. Thereafter, it was running in.
It was running from February after immediately.
Running in this was released from the. They are
So,
aware
my
of
lord,
these
if the
orders.
Take note
matter
of
could have
They are
ran
aware
into-
of these orders.
So,
And
my
I'll
lord-
just hand over the order just to allay that.
Give a copy to him.
Yes. They're all part of the proceedings. Is aware of this order.
No, if we were aware, then we would have appeared on 1st of August.
They're on the servers.
All right, very well.
Now, my lord, secondly, my lord will see in the affidavit, all the, my lord, injunction order, this, my lord will see from their affidavit in support of the originating summons, my lord, the apprehension that has been my lord, given, my lord, is without any substantiation. My lord will kindly take page number 35 of my stay application, the last 4 lines of paragraph number 17, just above paragraph number 18.
Yes, yes.
The plaintiff reasonably apprehends that the entire shareholding of Damodar Das Vadhva, now parked in the name of Anushwa Pujara, will ultimately go to Nirmal Pujara and Jayant Pujara if not already inherited by them. Nothing to do with the trust, nothing to do with the company yet. Kindly see page number 35. The allegation that has been made through submission is that the trust properties would be mismanaged, siphoned off. Kindly sees the plaintiff reasonably, last 4 lines of paragraph 17. The plaintiff reasonably apprehends that the entire holding of Damodar Das Vadhva, now parked in the name of late Anushwa Pujara, will ultimately go to Nirmal Pujara and Jayant Pujara if not already inherited by them. The plaintiff submits that Vadhva Endowment Endowment Management Private Limited and Jerambhai Management Services Private Limited are thus presently under the complete control of Nirmal Pujara and Jayant Pujara. So
Yes,
it
they
is,
are apprehending that you will siphon out.
so the main question, my lord, my lord was hearing Mr. Dutt, was that whether a company can be a trustee or not. That company was appointed in 2010. No problem with that till 2024 when they found out that,
That we cannot go into the
No.
merits. Just like
What-
Mr. Dutt's submissions on merits, we won't look into at this time.
then my lord,
Apart from prima facie,
then my lord,
whatever is on the affidavit.
very well. My lord, one last
At
submission.
this stage.
My lord, one last submission. Kindly, for the time being, let us assume that this is a usual suit. It's not an originating summons suit. It's a usual suit. A court has the jurisdiction to pass an ex parte ad interim order, but there are certain restrictions, there are certain conditions. that have
Parameters
to
are
be-
there, yes.
My lord, number one is reasoning that Mr. Ray had already
Reason,
submitted.
yes.
Now, my lord, the principles laid down in Morgan Stanley and my lord,
Morgan Stanley,
my lord, that the grant of injunction, the refusal of injunction would create more.
Charter's case,
My lord,
all
for
the judgments.
6 months, these matters were running in the list. There was no urgency. Suddenly, on that date itself, urgency arose, and these are not even recorded in these orders, my lord. My lord, I have brought the judgments of Morgan Stanley and Shiv Kumar Chatterjee. I'm not.
1993 3161, 1994 4225.
I don't know. So, my lord,
Oh, I remember up to that. After that, nothing. I don't remember anything. I remember the names only.
my lord, and my lord,
The
these
complete
judgments are even being followed.
Short-term memory loss. Yes.
My lord remembers the right things, my lord, till what is required.
Rights become wrong now
But and
because there are so many judgments after that.
but
Settled principles, unsettled.
But now-
Settled principles.
I can show there is another judgment in 2025 passed in
There are whatever proposition you name a proposition, I'll give you a judgment for that.
all the time saying,
Every
in
proposition, contrary
2025
proposition.
recently,
Every proposition there is a judgment. So let us not be too much on judgments.
they follow,
Let us
but
be on conscience.
all the time saying, my lord, the settled principles have been given in those two judgments.
Yes,
which are being
parameters of grant of
followed. Even
injunction.
those are not satisfied.
Yes, also Mr. Datta has also argued on that it has been discussed or whatever. We'll consider that.
And as my lord has already pointed out, the difference between rule 1 and rule 2. Rule 1 is for framing of questions, and rule 2 is one has to apply separately for an order for administration.
But at the end of the day, let us take this. Suppose even if it's under rule 1,
My lord.
two things. Rule 1 contemplates two types of genres. One is following questions or matters.
My lord.
Now, therefore, matters read with say D and E
Yes, my lord.
of rule 1.
Yes, my lord.
Doesn't that contemplate passing orders on that? Because questions, yes, we can understand any question affecting the rights, such and such, or matters. What was the use of putting in or matters? Directing the executor, he is directing the executor, administrator, or trustees to file any account.
My lord,
And if is the approval of any sale.
My lord, I would humbly submit that these are number one questions. My lord is saying
It can
also,
be granted at the final stage.
yes.
But then, if that be so, then the same principle applies that if something can be granted at the final stage, to protect that, in aid of that, why shouldn't identity power be denuded? The court should be denuded from the identity power to grant injunction or whatever to protect that final relief. Because in rules at rule 17 stage, direction can be given and order will have the effect of a decree.
My lord.
So if that can be done at that stage, in aid of that, in the interregnum, why shouldn't? Because nothing will remain; it will become infructuous.
My lord, I would humbly submit that rule 1, my lord, contemplates determination. Whether it is question or matters, my lord, it is determination.
All right.
Without administration of the estate or trust of any of the following questions or matters.
And
Now, let
how
us-
do you explain for such relief of the nature? The relief is circumscribed by determination.
Yes, my lord. The
For such
yes.
relief of the kind nature of kind. So that Mr. Rai has
Yes.
already argued, relief and determination has to be read together.
Right, my lord. Number 1 is that. Number 2, my lord, so far as order of administration of estate is concerned, there is a separate provision given. 2 cannot be read into 1. 1 specifically it has been given as rule 2. Then, my lord, it cannot and ought not to be read into 1, my lord. Specific provision is there. And, my lord, that can only happen, my lord, after, my lord, 17.
But after 17, if it can be done, protection can be given. Now, just like in a suit also, after he taking evidence and all, order 20 says decree can be passed and those things. Now, but identity power is there all the same.
Here, my lord,
See, in aid of that final relief, if directions can be passed at 17 stage after giving them, after
my
their
lord, here, my lord,
why shouldn't it be
the
granted?
plaintiff has to take a decision whether to go and file a regular suit or whether to approach an originating summons. My lord will see that in the affidavit in support and even in the originating summons, questions are enumerated.
Yes.
My lord, this originating summons is not supposed to replace the suit. If everything that can be done in originating summons, then there would be no requirement to file any suit. And my lord has already seen that the originating summons is not in proper form.
8 days notice contemplated.
8 days notice was not contemplated. It was not there. But I would say, I would humbly submit, and I will go on to the extent of saying that this chapter 13 was used to obtain an ex parte ad interim order. Because if this was in a form of a regular suit, perhaps this ex parte ad interim order without issuance of notice would not have happened.
So you cannot pass judgment today.
Very. And my lord, I have already, my Mr.
only
Ray had
come back on-
already placed that division bench judgment based on which, my lord, the impugned order was passed, which is not what is reflected in the, which is not what was
We
reflected,
can pass our order only on next Wednesday. Before that we can.
my lord.
Because it's a negative order, restraint order, we won't grant a stay at this stage. That would be allowing the appeal before hearing it finally, deciding it.
Just my lord, risk of being reprimanded. 10-second point, well, only on the point of the unreasoned order.
It
of
cannot be,
being
this will not end then.
No, no, my lord, supplanting, my lord, your lordships are
And
aware
now you
that
cannot.
my lord, in appellate jurisdiction, or even if the order is unreasoned, my lord, if otherwise your lordships feel, my lord, exercise appellate
Heard
powers,
learned
my lord
counsel for
can
the
support
parties,
position.
hearing is concluded and the matter is, sorry, heard learned. So, do we say that we have heard the appeal itself because we have virtually heard the,
Yes, my lord.
what, nothing will remain in the appeal.
My lord.
On consent of parties, comma, the appeal itself is taken up for hearing, full stop, hearing is concluded and judgment is reserved. Judgment is reserved. এটা পাঠিয়ে দেবে যত
Next Wednesday.
What?
This is money. normal process में चलते बड़ी तब तो पूरा stay हो जाएगा ना এটা একবার বলবি
May I mention this matter of circuit bench? After your lordship judgment dated 30th of July, we had filed a claim of refund. Now, after 1 month also as directed by the judgment, they have not complied with it. So while filing the contempt lordships, the department filing section is saying that you have to take a leave from the court because then only we'll get it filed.
Leave is granted.
Grateful.
Tribunal application.
Yes.
Tribunal application.
Lord, mentioned on 3rd September, praying for extension of time for filing opposition, my lord. I think it will come, only 2 files have come, one is yet to come. I have inquired from the court officer.
Dekhen in to mention.
Lordship.
I have your lordships kind leave to mention a appeal. Paper books have been filed, lordship. This is only for
No hearing now.
a very short point of law, lord.
Call on the list. What is the correction?
Lord, I had mentioned this matter
Yes.
with. Lord, may I hand over? Lord, while transcription, my lord, perhaps, my lord, there are certain things which have gone. Your lordship kindly comes to page 2, my lord.
Yes.
My lord, that's this sentence, the second sentence, my lord, second line, during, etc., my lord.
Yes.
My lord, this has gone up. If your lordship remembers, my lord, before the Thika controller, had held that it is not a Thika property. Against that, the returnees had filed an appeal before the tribunal.
Right.
Now, before the tribunal, Arun.
So the demise happened later.
Yes. So therefore, my lord, lordship will kindly pardon. Just written it in red, my lord.
No, absolutely. Yes.
My lord, if it's written this way, my lord, last sentence, the first bench of the tribunal, by impugned order dated such and such, allowed the application for substitution.
Yes, obvious.
Etc. This is one, my lord.
Right.
My lord, second, my lord.
Second, para 2 also corollary of that.
Yes, my lord.
Right.
This sentence has to be deleted.
Yes, true. And
Lord,
what else? Mr. Basu, you have got a copy of this correction?
Just now, the corrections, my lord, that is correct. They all ordered.
Any other
Actually-
correction?
My lord, lordship will kindly come to the last page 13, my lord.
13 years.
My lord, the last
Yes.
paragraph 30.
Tribunal.
36, my lord.
That is also true.
It should be before the tribunal, my lord.
No, right.
And the last paragraph, accordingly, LRTT, so on.
Yes, because if the tribunal did it, then
Yes. And then was allowed. And then last page, my lord.
Yes, you're right.
And the last page, my lord, it's a miscellaneous case number. It should be OA number 1433
Right.
of 2014. Yes. Because this miscellaneous case was before the Thika controller.
True, but we are thinking then should be reflected in the learned counsel, Mr. Mithun is also there. Learned senior counsel appearing for the appellant, for the petitioner, writ petitioner, hands up a copy of the corrections which ought to be incorporated in the judgment dated August 21, 2025, since certain errors had crept in inadvertently in the said judgment. Full stop. Learned counsel for the respondent. Mr. Bose, you don't oppose this.
No, I don't.
Learned counsel for the respondents does not oppose the said corrections. Full stop. Accordingly, the judgment dated August 21, 2025, passed in WPLRT 173 of 2024, be deemed to stand corrected by incorporating the necessary corrections as per the corrected copy of the said judgment handed over in court today, comma, by incorporating the said corrections in paragraph numbers 1, 2, 36 and 39 of the said judgment. Full stop. The office shall incorporate the necessary corrections in the said judgment, and the corrected copy shall be uploaded afresh. Thank you.
My lord, one other point, my lord. So far as the appearances are concerned, my lord,
Yes.
my lord, there's been if your lordship kindly sees, the second name should be Subrata Kumar Basu. And then after this Onkit Das should be Onkit De, my lord. And Mr. Shatrujit Sen, that is Mr. Shako Sen's son's name has been omitted, my lord. He has abroad, my lord. He's left this morning, as a matter of fact. My lord, his name has been omitted, unfortunately.
তাহলে যেখানে
So, my lord, I've given the slip, my lord. Slipটা দিয়েছি।
in the appearances as reflected in the said judgment, এটা last sentence এর আগে হবে, official. In the appearances on the date of the judgment, comma, the name of Mr. Subrata Kumar Basu has wrongly been depicted as Mr. Subrata Basu, whereas the name of Mr. Shatrujit JEET Sen has been left out despite Mr. Sen having appeared for the petitioner. Full stop. Let the name of Mr. Subrata Kumar Basu be corrected accordingly, and the name of Mr. Shatrujit Sen be incorporated in the list of appearances at the said judgment.
And Onkit De, my
Stop.
lord.
The name of Mr. Onkit Das, comma, appearing in the list of appearances for the petitioner shall stand corrected as Mr. Onkit De, DEY. এটা রেখে দাও, এটা এতে স্টেপল করে রেখে দেবেন। এই কপিটার সঙ্গে স্টেপল করে দিন, যে কারেক্টেড কপিটার ভিত্তিতে ডিপার্টমেন্টকে বলেছি যে কারেক্ট করে আপলোড করতে, এটা দিয়ে দাও, ওটা স্টেপল করে দিও। থ্যাংক ইউ। নেক্সট। Yes.
On the other day, my lord was pleased to direct me to
Private respondents are appearing. You have served up.
Lord, it has been refused.
Refused, then good service. All of them.
All of them.
Refuse is good. Learned counsel for the petitioners files an affidavit of files a fresh affidavit of service along with envelopes indicating that the postal articles sent to the private respondents have returned with the endorsement refused, comma, which tantamounts to good service, full stop. Accordingly, the writ petition is taken up for hearing. Yes.
Lordship, kindly consider, my lord, page 105, the impugned order. My lord, it has been rejected since, my lord, alternative amity is available, my lord. Lordship, kindly consider page 105.
Land Reforms Act একটু দাও।
Lord, here, my lord, I have challenged the action of the BLR. Lordship, kindly consider 10-1, my lord, 1.
Yes, page 1 of.
My lord, page, Lordship, kindly consider section 10-1.
10.
My lord, 10-1 is subject to the, my lord, provisions of section 6
Any order.
and other any order. My lord, here, my lord, what happened? My lord, my father-in-law, our father-in-law, the applicant's father-in-law, my lord, he was the original owner of the land in question. My lord, his name was recorded in the LR record of right. After his death, the name of his son was recorded. His son's, my lord, gifted the land in favor of the present petitioner. They are the wives. Now, my lord, they made a prayer for correction of record of right in their name. That prayer was allowed under section 50. My lord, subsequent thereto, the private respondent, my lord, they have not objected at the time of my lord correction of record of right. They appeared. But my lord, they filed an application under section 51F, my lord, for my lord revision of record of right. My lord, that order has been passed, my lord, by referring the matter for my lord correction of LR record of right before the my lord additional district magistrate and district land and land officer Purva. My lord, that will appear from the order. But my lord, by not taking any my lord permission, he has further proceeded and issued a notice. The BLR has further proceeded and issued a notice for correction of LR record of right. This is the my lord whole crux of the matter. Now, lordship kindly consider, my lord,
What is the impugned order of the BLRO?
the BLR is impugned order.
Order which you challenge before the tribunal?
Yes.
My lord, page
My
24.
lord, I have challenged, my lord, the notice, impugned notice. Lordship
24,
kindly consider 103 first.
order number 8.
103 first. My lord, that notice was served, my lord, upon us, my lord, for correction of record after passing of this order. Lordship kindly consider, my lord, page number, my lord,
103 we have seen, yes.
101 and 2. My lord, against that order, my lord, we have preferred an appeal. That appeal is pending before the appellate authority. Now, my lord, lordship kindly consider this order. My lord, at page, my lord, 102. Lordship kindly consider. My lord, last, my lord, para, drilling assistant directed to forward it to the, my lord, additional district magistrate and district land and land officer, South Chobis Pargana, my lord, with the case record for necessary correction as per the existing provisions of law. My lord, against that order, my lord, and my lord, he further passed an order that the record of right will remain at the arrest stage. My lord, against that we prefer an appeal. That appeal is pending. And my lord, without taking, my lord, on the hearing, my lord, that will appear from, as will appear from page 103. My lord, we have requested the BLRO, my lord, to show the permission, whether at all accorded by the district land and land funds officer or not. My lord, that order is not there. But even then, he is proceeding for correction of LR record of right.
Ultimately, you have challenged this notice. So you say there is no provision of challenge under
Yes,
the
because
Land Reforms Act against a notice. If it is an order, then you can prefer an appeal under
Yes,
either
but-
51A4 or 54.
My lord.
But this is just, you have challenged the notice. Let us see your challenge before the OA, the
Lord,
prayer
to
in the
kindly
OA.
consider that I have annexed.
55, it starts.
My lord.
Just the relief short.
Lordship, kindly consider the prayer. My lord, page my lord 66. Direction upon the respondents, most particularly the block land and land reforms officer, not to proceed with the with any further in connection with the miscellaneous case number ATO by staying the hearing purportedly fixed on ATO.
And you say because it has already been referred to the DLLRO,
DLLRO.
therefore a fresh proceeding should not be initiated. That is
Received until unless that permission is not being granted. And my lord, I have also prepared an appeal against that order.
Yes, Mr. Galib, what do you say?
My lord, from 11th July order, there is an appeal.
Yes.
That is
their grievances, despite that you have initiated a
now,
fresh.
my lord, now my learned friend is
They're challenging the notice only.
partially correct. My lord, now after this 11th July order, if your lordship may kindly, my lord, comes to my lord, page, my lord, 63 and 64, my lord, of the writ petition, my lord. Page 63 and 64.
Yes.
Kindly sees, my lord, paragraph 6.16. 6.17. What does 6.16 say? The BLLRO, without waiting for the permission from the office of the ADM and DLLRO, further proceed with for correction of record at his own wish, and for the same he had issued a notice of hearing so and so. Thereafter, the applicants duly appeared. 6.17. He has been participating and submitted to the jurisdiction. Appeared the hearing, requested the BLRO.
That is on the merit of the challenge, but it could not be said to be not maintainable. Tribunal has just said that it is not maintainable. That could be your argument on merit in the OA that they have already submitted
No,
to the
tribunal
jurisdiction.
is of the opinion, my lord, subject to your lordship's, my lord,
Yes.
correction, my lord, that since you are agreed,
3A means alternative
you
relief
should
is
go
there.
for 54. You should go under
54 is not maintainable here against a notice. Notice against notice 54 is not maintainable. Please set it aside. In view of the short point involved, comma, we take up the main writ petition along with the connected application. Full stop, next para. The learned counsel for the petitioner submits that the writ petitioners, comma, being aggrieved by an order passed by the
Page 100.
51 by F was passed by whom? By the BLL?
by the BLR.
By the concerned BLLR under section 50 within bracket 1 within bracket small f of the West Bengal Land Reforms Act 1955, comma, has already preferred an appeal. Full stop. In the said order under section 50 within bracket 1 within bracket small f, comma, the healing assistant was directed to forward the matter to the additional district magistrate and district land and land reforms officer within bracket DL and LRO, comma, South 24 Parganas with the case record for necessary correction as per the existing provision of law. Full stop, it is submitted that despite such direction and the pendency of the appeal at the behest of the petitioners, comma, a fresh notice was issued by the concerned BL and LRO purportedly under sections 57, comma, read with section 50, comma, 50A, 50 and 50A of the 1955 Act, comma, in connection with miscellaneous case number 686 of 2023, full stop, challenging such issuance of notice on the ground of prior pendency of the appeal as well as no permission was obtained by the BL and LRO from the DL and LRO, comma, the writ petitioners preferred an original application before the learned before the West Bengal Land Reforms and Tenancy Tribunal. Full stop. However, comma, the learned tribunal, comma, by the impugned order dated July 15, 2025, comma, has held that the original application is not maintainable in its present form and in the eye of law under section 10 within bracket 3 within bracket small a of the West Bengal Land Reforms and Tenancy Tribunal Act, comma, 1997, comma, observing further that the order would not preclude the applicants from preferring appeal before the appropriate authority, A capital, in accordance with law. So, next para, it is submitted that the notice impugned before the tribunal is not amenable to an appeal either under section 51 capital A within bracket 5 or under section 54 of the 1955 Act, and as such, comma, the tribunal refused to exercise jurisdiction vested in it by relegating the matter to the the appropriate authority. Full stop, next para. Learned senior government advocate places reliance on the averments made in the original application, comma, to the effect that the BL and LRO, without waiting for the permission from the office of the additional district magistrate and DLLRO, comma, proceeded for correction of the records of rights. Full stop, next para. However, comma, we accept the argument of the writ petitioners to the effect that the notice impugned before the original application is not amenable to challenge either under section 54 of the 1955 Act, comma, since it is not an order passed by any authority under the said Act, comma, nor under section 51 capital A within bracket 5, comma, since there has not arisen any occasion as yet for any rectification, for any correction of the records of rights having been effected, but the matter is still at the inchoate stage of issuance of a notice. Full stop, thus,
Lord,
comma,
May I just point out one thing? This notice is the continuation of the earlier same miss case number 686, which your lordship is finding in the impugned order.
full stop,
Just passed in the
Des-
same.
despite the argument of the state that the notice is in continuation of the previous proceeding, comma, fact remains that a challenge to a notice cannot be preferred under any of the provisions of the 1955 Act to any appellate authority. Full stop. Hence, comma, the learned tribunal refused to exercise jurisdiction vested in it by law in holding that the original application, comma, challenging the impugned notice annexed at page 103 of the present writ petition is not maintainable, comma, as there is no other equally efficacious alternative remedy before the writ petitioners. Full stop. Hence, comma, WPLRT 135 of 2025 is allowed on contest, thereby setting aside the order dated July 15, 2025, and directing the tribunal to decide the original application of the writ petitioners bearing OA number 1591 of 2025 on merits upon giving adequate opportunity of hearing to all contesting parties and in accordance with law as expeditiously as the business of the tribunal permits. Is there any can?
No.
Very well. No order as to cost. প্রথমেই যেটা বলেছি, the in view of the short point involved, appeal along with the applicationটা বাদ চলে।
As expediently as possible, within
As expeditiously as possible, ওটা it has not yet started. Tribunal is hard pressed.
But we are getting the date after 1 year.
We know that that's because the tribunal is already hard pressed. That's why we don't want at this stage. No, it has not yet started. This was a non-starter actually. Next. T.
Affidavit in service.
Good service.
Yes, madam. Sir, this
So don't look at them. The service is good from the affidavit of service.
Yes, madam. Only state is party.
Only state is.
All right. Yes.
Madam,
What's the matter?
Subject matter challenge is that, madam,
Yes.
my predecessor, my lord, filed a written in V form, whereby, my lord, by mistake, my lord, 10 decimal of my Bastu land was in the list of surrender land. And
Was?
In the list of the surrender land.
Achha.
And my lord, subsequently, long back, my lord, we detected that defect. My lord, we, the petitioner, the legal heirs of the original Big Riot, my lord, we file an application to that effect. Kindly allow me to surrender equal quantum of the retained land, that is the 10 decimal, and allow me to withdraw that.
After the vesting, can you do it?
But the vesting order was
Once vested, it cannot be divested. That is
my humble submission is that
yes.
10
An exchange, my lord.
exchange.
He's taking that. Can't.
Yes, since the 10-2 possession was not taken up.
That could have been done. You could have offered this land at that juncture.
My lord,
but once it is vested,
but possession ought to have taken. Till today, they have not taken it.
Under Estate Acquisition Act, vesting is automatic upon the notice. Not dependent on the possession, is it?
My lord, Lordship, my lord, kindly allow me to submit to that effect. That
Yes.
till possession is not taken, physical.
Yes, yes. To cite that judgment, Estate Acquisition Act din.
Yes.
1953, West Bengal Estate Acquisition Act.
My lord, cited that judgment before the tribunal.
Shulekapal.
Yes, Shulekapal.
Oh,
yes.
My lord, para 10 and para 11.
Yes.
Admittedly, possession was not taken up.
Yes, what do you say about Sulekha Pal?
Other,
Yes, you complete. Sorry. Yes, what is?
I have other.
What was the premise of the learned tribunal?
But they noted that kindly is the impugned order.
Yes.
Last annexure, my lord, page 58. He noted the entire case that equal quantum of land we want to surrender. But he says some revised option was filed, but that is not correct. On the basis of the report submitted by the government representative, they relied and they passed the order without considering the exception of the report submitted by us. That this is not correct position.
Report was filed by the state.
Yes, that I have annexed.
My lord, page 51, my lord.
An exception to the report is also not accepted.
No, you had offered this land, but it was wrongly recorded, or you had made the mistake.
My predecessor made the mistake.
Your predecessor had made the mistake.
Still, we are existing, my lord, domestic houses there. We are residing there. So that mistake which was committed.
Why did you come up after 40 years?
My lord, that is true. On that score, they have not decided. But the law says that unless you have taken possession of 10(2) as physical person, but I am entitled to revise my fairness is that I am going to surrender equal quantum of land from my retained land. Retained land. Entire family is residing there. My dwelling house is there. But other two judgment of single bench of this honorable court
must be following Sulekha.
Yes.
But Sulekha's judgment, I mean, it's Supreme Court is binding. But 4 and 5 are very clear.
But
10(2) says 10 starts with 10(1) says upon the publication of any notification, the collector shall take charge of the estates and interest of interview which vest in the state under section 5. Section 5 reverts back to section 4. 5 says effect of notification upon the due publication of notification on and from the date of vesting, estates such and such shall vest in the state free from all encumbrances. So the date of vesting, Sulekha Pal's judgment is there, but
paragraph 10 of that judgment.
Section 4 and 5 are very clear. The date of vesting is it's section 4 notification.
Paragraph 10.
10, yes. Delay and latch is no merit viewed in such context. Authorities of the state have not lawfully and factually.
And paragraph 12. But government would not deprive equal quantum of the land I am going to surrender. This is the
the paragraph 12 Gaur Gopal Mitra has been relied on.
Yes.
There the proportion is different. Subtly different. Here, in other words, it will mean that so long as the media has not delivered possession, has no right to claim retention. Very least, but this is Supreme Court, this is binding on us. Yes, we should look into the section.
My lord, my learned friend,
yes,
senior friend, my lord, he is willing to take plot number 2434, which stands vested, and is in exchange wants to give 155.
Stands vested is now diluted by Sulekha Pal.
No, lordship. May I just
argue on that.
Pal, my lord, is very much distinguishable. It's on different aspect altogether. So, my lord, what Sulekha Pal, my lord, may I first deal with Sulekha Pal. My lord, may I respectfully invite your lordship. My lord, Sulekha Pal, my lord, paragraph. What was the issue in Sulekha Pal, my lord? Paragraph 4 kindly says, lordship.
Even obiter of Supreme Court is binding.
No, it is on a different issue altogether. Here, my lord, Sulekha Pal, the exercise of retention was not at all exercised by the intermediary. Here, the intermediary has not only exercised his choice of retention, but also thereafter amended the list, and that was done. Here,
Sulekapal issue was the gentleman intermediary did not at all exercise his choice of retention as contained under section 6 of section 5 of the 53 Act. On that aspect of the matter, Honorable Apex Court pleased to say, yes, until you exercise, until section 10(2) is pressed into action, until position taken by the government, the intermediary shall be given the choice of retention. Not only that, even it goes on to say in Monoranjan Belthora also we have seen that the choice of retention power is heritable but not assignable. So even heirs can do it. That is exercise of choice of retention. But here intermediary has done it.
But that process has not become conclusive before you take position.
No, my lordship kindly sees me. Here it is out and out. It has been deprecated by the Honorable Division Bench of our court because kindly sees the issue in Sulekha. I know Sulekha, my learned senior friend, we rely upon.
Look at even after delay, it can be exercised. Retention can be exercised.
No, my lord, it is not detention. It is exchange today that I want to give this and take back. It has been deprecated after 40 years. Our division bench has deprecated after 17 years. It was deprecated. It can't do it. So kindly sees me issue, my lord. Kindly sees page 2, paragraph 4 of Sulekapal, page 257, placitum, my lord, B. My lord, the sentence starts with, my lord, kindly sees, this order came to be passed on the ground, lordship, that's it. In spite of the parties having said to have been given sufficient opportunity, did not choose to exercise an option to retain any land in their class possession, leaving an impression that they are not willing to retain any land in class possession. So that was the issue. The choice of retention was not at all exercised. In that perspective,
so once you exercise, you cannot.
Now heirs come before this honorable court. That your lordship will find
the original right had exercised
in this matter before
in this matter.
Yes.
Now they come and try to.
So now Shulekha, let me clarify. Now kindly comes to placitum G part. Thereafter, heirs of this.
So that you understand. Yes, Shulekha is clear. Yes. So heirs can do it if you never did it. You say once you do it.
Now here what?
Yes.
If I may, my lord, respectfully invite your lordship to page 51, my lord. That is what the Bureau's report, my lord, was filed, my lord, before that Learned Tribunal. Kindly seize, my lord. The first para says BR case was completed in 1974. Page 51, my lord. First paragraph. To consider the representation of so and so, BR case 74, a finally disposed proceeding under section 6, and to allow retention of land, RS 24 so and so. Now kindly comes to fourth paragraph. 1, 2, 3, 4, 1, 2, 3. Fourth paragraph, my lord. The predecessor in interest of the instant applicants held prescribed ceiling surplus land and had not exercised the choice of retention of land under section 6(1) within the prescribed period. As a result of said period was initiated by the and due opportunity was given to submit form number 1 and statement for choice of retention of lands by the intermediary. It is also on record that predecessor in interest exercised the option of choice and submitted form 1 and statement for choice of retention on 21st August 1974. Even after that, after an amendment petition was filed on 30th April 1979, stating that some plots were omitted due to ignorance to include in that option, statement submitted on 21st August 1974, which was duly considered and allowed by the revenue officer for the sake of justice. Thus, the said proceeding was finally disposed of in the year 1979. After that, the heirs now come in the year 2020. That is the representation at page 48. At page 48 is the representation. In the year 2020, after 40 years, they come and say that we want to give back this land and take back that land. It's an exchange.
Amendment application was filed by the original right or
by the intermediary. Everything was by the
intermediary.
No, everything. So, my lord, now these heirs come in the year 2020 with a representation that is at page 48. So, my lord, lordships, my lord, already, my lord, there is a full bench judgment of this honorable court also.
Cite those.
Although the reference is, my lord, the reference before the honorable full bench was that whether the right of exercise of retention can extend up to post vesting transferee or not. It was answered no. The right of retention does not extend to post vesting transferee.
Vesting is not complete unless under Shulekha, unless 10.2 is position is taken under 10.2. So this is not applicable then.
No, my lord. Shulekha, my lord, I have already, my lord.
Shulekha observes in para 10.
Lordship.
The Supreme Court categorically observes, as rightly pointed out by your learned friend, that authorities of the state have not lawfully and factually dispossessed the petitioners who are heirs of intermediary of the khas person right to vindicate and protect their interest in the lands in terms of enabling provisions of a would annual till they are dispossessed in the manner envisaged and by observing the formalities contemplated under the statutory provisions. Therefore, as per Shulekha, that right remains till they are dispossessed.
No, my lord, Shulekha Pal, in my humble understanding, it was in the perspective of when the intermediary has not at all exercised his choice of retention. And this is a case, my lord, which is out and out issue of exchange, which is not at all firstly contemplated in the Estate Acquisition Act.
Not exchange, it has not yet gone to you. Unless the vesting.
It has come, my lord, pre-existing right, title, interest, my lord, by operation of law, my lord, it has already come because Arun Kumar Basu, lordship kindly sees the first next judgment, lordship, if I may place this. Arun Kumar Basu judgment by the Honorable Supreme Court, what does it say, lordship kindly sees? Kindly sees, my lord, paragraph 5 and 6 over there. So,
first let us complete this full bench.
Full bench, lordship. Full bench, my lord.
Full bench.
While answering the reference,
Full bench reference.
kindly sees, my lord, in paragraph, my lord, 13, lordship. In our opinion, right of retention on the statutory scheme has been reserved for an intermediary. A post-vesting transferee cannot come within the ambit of that expression. The meaning and import of the term intermediary cannot be extended to cover a post-vesting transferee. We agree with the opinion of division bench in the case of Monoranjan Belthoria and the single man Ruthikanto Moshat. In a situation where a person has purchased land which is already vested in the state, the 1953 Act does not confer on him or her any right to retain such land by of an arrangement with the original intermediary. Such an exercise would require specific statutory provision like 14U of the 1955 Act.
This was in the context of post-vesting transferees.
Yes, the reference was that. But kindly sees, my lord, the 1953 Act does not provide for such exchange mechanisms. So, my lord, here.
Which paragraph?
That same paragraph, next line I was reading about, my lord.
Same
the 1953 Act, paragraph 13.
Yes.
After permissible course, the next sentence, the 1953 Act does not provide for any such exchange mechanism. So, my lord, this is, my lord, is an exchange which they are asking for. So, my lord, 1953 Act itself does not, my lord, contemplate, my lord.
No, here the subsequent purchaser seeks an exchange.
So, my lord, lordship, kindly, my lord, appreciate that.
Not permitted.
But today, the present context, in the present issue, they are willing for exchange.
They are the heirs of the original intermediary. Not
Certainly.
Transferees. This governs transferees.
Yeah, it is post-vesting transferee.
Post-vesting transferee. Vesting happens on section 4 notification that has been held here also, and the statute provides.
And my lord,
Shulekha did not in terms hold that vesting does not occur, but the right to retention was retained till after the till before the possession was taken, even after the vesting.
Provided the choice of retention exercise has not been at all exercised. That is what Shulekha Pal says, my lord.
Shulekha Pal does not say that it cannot be exercised multiple times before possession is taken. It is neither it only says that the right is retained, but whether till the possession is taken, it says that that right has not crystallized, that right has not finalized.
It can continue.
Yes, it can continue. So
because
if
it
the
is
right
heritable by nature.
if that right is not crystallized, then why can't they again change that their
But
option?
Milord, here
It is not a question of exchange. Exchange would happen only if it vests already. Retention, insofar as retention is concerned, the vesting concept is diluted because they are entitled to retain a portion.
no,
So
Lordship, kindly, Milord.
why can't they retain a different
Then
portion?
may
I mean,
kindly see,
before-
Milord, it is already a pre-exist by operation of law of section 4 and 5. The pre-existing right, title, interest of the intermediary stands vested, Milord. Milord,
but
kindly
still they
once,
can retain as per Shulekha. Still they can ask for retention of a portion.
the intermediary has already exercised that right. That is, Milord, where, Milord, I am on, Milord, subject to your Lordship's, Milord, correction. I am on, Milord. You kindly seize, Milord, once more, Milord, full bench judgment. Paragraph, kindly seize, Milord. One more paragraph, may I, Milord, respectfully show your Lordship. Paragraph, Milord, 11, kindly seize. What does it say?
In fact, Supreme Court in Shulekha relied on the judgment of Gaur Gopal Mitra,
Yes.
where the situation was different. But Gaur Gopal Mitra also held that that has to be exercised within 60 days and the timelines were adhered to.
With regard to intermediary.
But Shulekha diluted that also.
No.
Shulekha relied on Gaur Gopal, but does
rely-
not restrict it to 60 days.
But Miller, kindly see then Shulekha also relies upon Arun Kumar Basu. I am showing your Lordship. Kindly see paragraph 18. Kindly see paragraph 18. It relies upon Arun Kumar Basu, Milord.
Yes.
Now, what does Arun Kumar Basu say? Kindly seize, Milord. I have already handed over, Milord, 2 copies.
As to the extent and effective extent nature of it. Yes.
Kindly seize Arun Kumar. I have handed over, Milord, 2 copies. Kindly seize paragraph 5 and 6. 5, Milord. It is sought to be contended by the learned counsel for the respondent that though notice under section 10 was issued by the collector for surrender of possession, it was withdrawn and thereafter the vesting does not apply to the company. We find no force in the contention. Once the land stood vested in the state free from all encumbrances by operation of section 4.1 of the Act, the mere inaction on the part of the collector in not taking possession of the land does not have any effect on vesting, which statutorily operated under section 4.1 of the Act.
We are of
It is
the
then-
same opinion also, but even after this, considering this, Shulekha opened up the retention scope.
No, Milord, that was Milord, on the choice.
If it vests, how can you now retain? If it has vested, it has
Yes.
vested. So even retention cannot be allowed.
Yes, no,
But
retention.
Shulekha allowed retention. So diluting that vesting. If X property vests in the state by virtue of section 4 and within the statutory time limit no retention is claimed, then it remains vested. Entire X remains vested. So, but if after say 20 years or 30 years, it is permitted to be retained, the retention right is kept alive, then that vesting is not so absolute as you are arguing.
But my Milord, here Milord,
Before position is taken, of course.
here position Milord,
Shulekha diluted Arun Basu.
Arun Basu is diluting the question of position.
Arun Basu could not dilute Shulekha because Shulekha came after.
Came after, but taken into consideration. Arun Basu has been taken into consideration.
Let us continue with
And Milord, kindly sees.
Is it stated that once it has been, once an option is given, you cannot give another option? In Arun Basu, has that been held?
It comes. It comes, Milord. Now, one
Supreme Court relied in Shulekha on Arun Basu was held contrary to Arun Basu actually. In a sense.
And
So therefore, the later judgment has to be taken note of.
now another judgment kindly sees. But how can Milord this Milord after 40 years a judgment? Tandon Brothers, 2001-5.
Tandon Brothers, there were brothers also. Arun Basu says something else. I mean, Arun Basu was diluted by Shulekha actually. Arun Basu is very specific, as we said initially.
Milord, here,
that
Milord,
it is
the
sought to be
inter-
content, not accepted, not taking specifically what was held in Shulekha to be good law was held to be bad law in Arun Basu. Once the land stood vested in the state free from all encumbrances by operation of section 4.1, mere inaction on the part of the collector in not taking possession of the land does not have any effect on vesting. It's statutorily operated under section 4.1. This is precisely what we were saying, and Arun Basu also. No, Arun Basu also held.
The Tandon Brothers
Mr. Galib, please listen to us.
Lordship.
Arun Basu also reiterated this proposition, but Shulekha considered Arun Basu and opened up the right for retention.
But it was, my lord, when the retention, my lord, exercise was not at all, my
Since you
lord.
are so keen on Tandon Brothers, let us see a switch paragraph.
My lord, Tandon 2001, my lord. Kindly seize, my lord, page 669. Page 669, my lord.
Yes.
Placitum, my lord, C and D. While some submissions, the sentence starts with
Yes, yes.
though were advanced before the court in regard to the effect of the statute, that we need not dilate on this score, since on a proper conspectus of the issue, this court earlier categorically came to a conclusion that by and under the West Bengal State Acquisition Act, pre-existing right, title, and interest in the land stood extinguished and ceased to have any effect on and from the notified date, and stood vested in the state free from all encumbrances. So, my lord, this, since the my lord, existing right, title, and interest.
Why are you citing these? These Tandon Brothers and Arun, both were considered in Shulekha. And after that, both of these hold that no, with section 4 notification, read with section 5, vesting becomes complete on the date of the notification.
Lordship.
So therefore, no reopening of that.
Lordship.
Once vested, cannot be divested. Precisely what we were telling you at the inception. We are telling him rather. But both these judgments, after these judgments, Shulekha comes. And Shulekha says, no, till, yes, it may vest, it is silent rather on vesting. But it says that till possession is taken, right of retention can be exercised. So if right of retention can be exercised, then the right of retention is kept open. And as per Shulekha, whatever the original intermediary could do, the heirs can also do. It's heritable, as you said. So if the heirs can also do, let us proceed on the premise that the original intermediary is doing this. Once having given an option, he wants to take it back and give another option by saying that my Vastu was erroneously given.
B form, my lord, can't be given by the heirs as on date, my lord. They are coming for exchange of the, my lord, vested land and the, my lord, retained land, which were done by their predecessor. And kindly sees the division bench judgment of.
Let us see B form once.
Our division bench, what does it say, my lord? Kindly see.
No, first let us see that B form. That is under the rules.
Yes, rule 4A, my lord.
Which is form number?
Form B, lordship. Rule 4A, kindly seize, my lord. This is form number B. Kindly seize rule 4A.
Yes.
On this issue, may also, my lord, we have a judgment on of our
Make his choice by furnishing to the settlement officer or to the revenue officer authorized.
Every intermediary, lordship got it, 4A. Every intermediary entitled to retain possession of lands under subsection outside shall, if he chooses to retain any such land, make his choice by furnishing a settlement officer or to the revenue officer authorized by the settlement in this behalf before expiry of 30th April, so and so. Statement in writing in form B, appended to section schedule B, appended to those, and in form of substantially similar thereto in the manner indicated therein. So this was inserted in Millard, kindly sees, in 1958. Earlier it was only rule 4. Rule 4A was inserted, Millard, in the year 1958, 21st January. Earlier it was only rule 4. So, Millard, intermediary's right was there. And thereafter, because of judgments, Millard, he has crystallized to heirs. Now, Millard, kindly sees, we have a judgment of our Honorable High Court in second appeal.
Yes.
Krittibash judgment, Krittibash. Krittibash. দাও দুটো কপি দাও এখানে নেই এখানে কৃত্তিবাসটা দাও what you kindly sees This 4A, my lord, interpretation was taken up in a second appeal. When the intermediary was allowed to exercise his amendment, kindly cease lordship. It is, my lord,
Because you
1980
yourself allowed one amendment in this case, as per the report of the BLL.
Yes,
So
the-
therefore, you opened up the scope of amending.
No, he changed that some of my lands were omitted at the time of filing the original. That's why I want to include some other those lands which were omitted.
So therefore, you permitted them to amend,
He
whatever may be the quality or nature of the amendment.
Now what does
They're doing the same thing now. This is also an amendment they're seeking. Once you permitted them amendment.
lordship? It is lordship. Last, kindly seize me, lord. I leave to your lordship. It will open Pandora's box after 40 years, 17 years, my lord. Kindly seize.
You have not yet taken possession.
No, lordship possession.
It will not open Pandora's box. You have not closed the box as yet. You should have closed the Pandora's
I'll have
box.
to take instruction on that, my lord, whether possession, my lord, 10.
At least before the date of this application, it was not there.
Possession, my lord, is symbolic.
Achha, let us see which paragraph of this.
Ittibash, here, my lord, kindly seize.
Which para?
Para 2.
This is on the point, yes.
Plaintiff was a big right. He filed B form to retain lands in dispute suit. When the compensatory rule was published in the respect of the lands including lands in dispute, the plaintiff realized that due to inadvertence, the character of the lands as shown in B form submitted by him was wrong. It has been alleged that because of the said wrong description of the character of land, the land in dispute had been shown as vested and the compensation was determined on that basis. As soon as the said mistake was detected by him, on perusal of the compensation assessment rule, the plaintiff filed before the compensation office an objection in writing on 27 June 1966. So, my lord, as soon as. Now, what does the Honorable Court say, my lord? Kindly seize, my lord. In para 9, it is about the vesting of under the operation of law. Now, paragraph 10, what does this say? Kindly seize, my lord. Para 10, as stated earlier, in this case, B form was furnished on 12th November 1957. Under Rule 4A, Lord, am I reading the right paragraph, Lordship? Lord, under Rule 4A, the plaintiff had further right to amend the said form or submit a fresh form within 30th April 1958. Admittedly, this was not done. It is not in dispute the plaintiff by furnishing second form did not want to retain land beyond the prescribed ceiling. It is from the compensation assessment rule the plaintiff became aware that there was a mistake in describing the character of land. He therefore submitted another B form with a view to correct the mistake occurred in first B form. And thereafter, on the proper construction of section 6.1 and rule 4A of the said rule, I am unable to agree with the conclusion of the learned subordinate judge that there was no scope for submitting a second B form. Under any plea, it cannot be the insertion of the legislature once a B form has been submitted by an intermediary. It cannot be altered or amended under any circumstance, even though it may lend to hardship or
This is against what you are saying.
No, my lordship.
It says it cannot be the
Within a
intention.
reasonable time. No,
It cannot be the intention of the legislator that once a B form has been submitted by an intermediary, it cannot be altered or amended.
And my lord, kindly
under any circumstance, even though it may lend hardship and lead to a hardship or injury,
and
the form once submitted cannot be treated as sacrosanct.
my lordship, the form once lordship.
Mistake may
creep in while fighting, so this describing the term. It is not in this for the character of the land has not been correctly described. Character of land.
If an intermediary having furnished statement discovers an omission or
time.
omission or mistake in the said statement, he may furnish a revised form. It will be unjust if a person having a bona fide is not allowed.
Is not allowed. The intermediary has a right to amend the form B already submitted within a reasonable time. That was the, my lord, a rider. Now, my lord, here the distinctive feature is, lordship kindly see at the very first, second 3 lines in para 10, it says that was furnished, B form was furnished on 12th November 1957. Under Rule 4, a plaintiff had further right to amend the said form or submit a fresh form within 30th April 1950. That means,
admittedly, this was not done in this case. That is what has been held. Read the next sentence.
Admittedly, this was not done. So here,
in that case, it was not done.
No,
but still it was held.
No, second option was given as because kindly come to my lord, Rule 4A. Rule 4A has come into, my lord, on and from 21st January 1958. So in this Krittibash case, he had the intermediary, had exercised his option in November 1957. So therefore, his chance was given.
Mr. Galib, let us read on section 10. Next page, last 5 lines of section para 10. Under section 6, an intermediary has the right to retain with effect from the date of vesting lands. If amendment of B form is allowed by the revenue officer, it will relate back to the date of filing of the first B form. And as such, the intermediary will be entitled to retain lands from the date of vesting, even where the possession has been taken by the state or other lands, of the lands other than the retained lands, and the lands are settled with the licenses. An intermediary may still exercise his right to amend the B form depending on the terms of settlement. It is therefore necessary to determine whether in this case intermediary parted with the possession. Same principle as Sulekha.
Now Miller kindly sees what does our honorable division bench say.
So this says that it can be amended and it will relate back to the first date.
But here Miller rule 4A was taken into effect.
And you yourself in fact permitted one amendment in consonance with this.
No, that is Miller and not amend.
And they say that our Bastuland was by mistake given.
That
So that's a mistake and that it comes within this.
Lordship, kindly Miller, next Miller, let me place this judgment. This Kittibash was taken into consideration by our honorable division bench, and kindly sees Miller, what does our honorable division bench say? A coordinate bench of this honorable court. It's an unreported judgment, my lord. The writ petition has been filed challenging the order dated so and so, whereunder the said learned tribe refused to consider the claim of petition for interchanging the vested land with the retained land after a lapse of 17 years. We also do not find any provision for allowing the petitioner to interchange the vested land with the retained land after a lapse of constable period. Mr. So and so learned counsel represents state and submits that herein. Now, my lord, kindly see the second page, learned counsel of the referred to the relied on a decision of this court in the case of Kirtibash. In support of his contention, the revenue officer can consider prayer of the intermediate for amendment of B form. Therefore, the decision of this court, in our opinion, has no manner of application in the facts and present case. In the aforesaid case, Kirtibash, this court found that the intermediate committed a mistake in describing the character of the land and therefore submitted another B form in order to correct the mistakes which occurred in the earlier submitted B form. The learned single judge also specifically observed in the aforesaid decision that the character of the land was not correctly described in the previous B form submitted by the intermediary. And therefore, a revised form B was submitted.
But here there was a mistake. They say my Bastu was
They
given.
never say this, my lord. They
That is their, please see their representation. My
Miller, kindly
Bastu land
please-
was given by mistake.
kindly sees, my lord.
Come to page 48. Mr. Khalid,
Lordship.
come read it out. Although it will be very difficult for you to read because it's in Bengali.
আমাদের বিনীত নিবেদন এখন আমাদের লিখিত ভুক্ত জমি পরেশান সূত্রে সালিয়ে হইতেছে উক্ত সম্পত্তি পিত্রমহ সোয়াংশ মতো ভুলবশত আমাদের বাস্তু সম্পত্তি তো মিল
Bastu was by mistake given.
But here, Millard, Millard, by the coordinate bench of our Millard court, Millard, it was deprecated after 17 years. And here, Millard, is after 40 years.
Distinguished, this Krittibash was distinguished by our division bench on the ground not of 17 years.
But character.
Mistake. There was a mistake. If
But
you see
here,
the
Millard,
division bench judgment, which you just now cited,
Krittibash.
not Krittibash, the division bench, Justice Pranab Kumar Chattopadhyay's judgment.
Lordship, WPLRT 48. Lordship.
In the case of, the court holds in the case of Krittibash Bhattacharya, this court specifically held that in the event of discovery of any mistake in the earlier submitted B form, intermediary is entitled. In the instant case, intermediary did not commit any mistake in any manner. Furthermore, revised form B was also not filed on behalf of the petitioner after discovery of any omission or mistake.
So when
Just
the
like that, they asked for an
intermediary did not do this. The thing which they are asking for the heirs, the intermediary did not do this. Now, page 48, Lordship kindly sees at the bottom, what do they say? They want that DAG 1541 Rakhia Dibo or DAG 2434 niye nebo, kindly at the top, at the bottom. So this is mirror the
দেশে
definition.
সেই মোতাবেক আমরা যে পরিমাণ জমি ভেস্টিং অর্ডারে ছাড়িয়া দিয়েছিলাম সেই পরিমাণ জমি রাখিয়া, দ্যাট ইজ দ্য ল্যাঙ্গুয়েজ ইউজ বাই এলএমএল।
No, kindly at the, so Milord, if at the bottom Milord, kindly say top.
ছাড়িয়া দিয়েছিলাম has not become conclusive by virtue of Sulekha.
No, Lordship, I am telling you,
Before you take position, it cannot be conclusive. Even as per Justice Ajit Sengupta's judgment, the single bench judgment.
But here the issues of exchange Milord and interchange, which Milord I am trying to Milord submit.
When will it come under exchange? Under the Transfer Property Act, if it is exchange, it has to be exchange. There has to be title. Now, if the right of retention is itself retained till possession is taken by virtue of Sulekha, then Mr. Gali, the rights have not been ripened, if we may say so. So if the right is not, the title is not ripened in the state, then why can't it be done? I mean, there's no question of exchange. Exchange, you can only exchange a property which is the title of which is which vests in you. That vesting itself has been diluted by Sulekha and
But Milord, their
Justice
challenge is,
Prithivas.
Milord, kindly appreciate one thing. The heirs at no point of challenges, Milord, that there was any irregularity in the Milord, vesting. There was any illegality in
Not
the vesting.
irregularity.
Milord.
Prithivas was a mistake.
But it's a concluded. It's a concluded, Milord. Milord, kindly appreciate. Arun Basu also kindly
Cannot
consider.
say it is concluded. Sulekha.
No, Arun Basu also kindly sees, Milord.
Arun Basu considered by Sulekha.
Sulekha Milord kindly, it was that intermediary did not at all exercise his choice of retention.
Sulekha says that before the possession is taken, he can exercise his right of
If
retention.
Milord, the intermediary, Lord, respectful reply, Milord.
And Prithivas says that even if he opted for retention, he can amend that if there is a mistake or omission. So Sulekha read with Prithivas says that before possession is taken, retention right remains, and that even once an option is given, that can be modified if there is a mistake or omission. They say there was a mistake, my bastu was given. Chhariya diyachilam means bastu was given. Bastu was chhariya diyachilam, put it in a negative term. It was not retained.
No, not Lordship, kindly appreciate.
Dhoriya rakhi nai.
But Sulekha Milord.
All the same.
Sulekha
Chhariya or Dhoriya is mirror image of
Sulekha
each
was
other.
against the issue, Milord, when the intermediate did not at all exercise. I am repeating, Milord.
Don't
same
repeat.
thing,
We have
Lordship.
understood. Hari.
Milord,
Yes,
kindly
what
appreciate,
about
it will
Mr.
open-
Khalid, there is nothing else on this. Let us not dwell on this same law point again and again. Any other judgment you are wanting to cite?
No, this full court judgment also I was willing to
Full
refer.
court you have already cited.
No, I was willing to refer
Don't
to one of,
multiply judgments on the same
no,
proposition.
same judgment, full bench, Milord. I was willing to refer to one more paragraph.
Yes. Full court only says section 4, on section 4 it vests.
Milord, paragraph 11, Milord. If I may respectfully invite your Lordship to Milord, page 9 of the report. No, page Milord 8, para 11, last 4 lines from the bottom. It is manifest from section 6.1 that the intermediary was entitled to retain certain land as on the date of vesting. The right conferred under section 6 of the Act to the intermediaries to retain the land does not mean that the retained land is beyond the periphery of the vesting under section 4 of the Act. The vesting and the right of retention are two different concepts, although operating simultaneously. It is clear that the intermediary was allowed to retain land out of the lands which vested in the state as tenants under the state, even though the factum of vesting of estates and the deemed settlement of rights right in respect to retained lands take place simultaneously. Yet in law, two must be treated as different on the first, the vesting of the state is absolute and free from all encumbrances. And secondly, it is followed by the state of riots right on the quantum proprietors. It is therefore only after the state have vested in the government, the right of the retention really arises. The word retention has a special significance under section 6.1, entitling the intermediaries to retain the land subject to undertaking certain exercise submission of B-form in due
Post
time.
vesting transfer was precluded. They are
So,
not
Milord,
specific transfer.
Lordship kindly. So, Milord, here, Milord, what Milord I am trying to Milord impress upon your Lordship is, Milord. Here, Milord, the intermediary had already exercised his choice.
You
of
are
retention.
repeating. You have heard it. Yes. What do you say about the 40 years delay? How do you explain that? Why should you exercise our equity jurisdiction in your favor?
Regarding
40 years, what were you doing?
40 years, that is admitted.
You cannot come up at any point of time. There will be no finality to anything.
But 40 years.
Yes,
but
albeit they have not taken possession.
their entire report says they have not taken position. And admittedly, we are residing there. But this is entirely
That from
mercy.
document is not clear, as of now, with position taken.
Where do they say the position is not taken?
Kindly take up the page 51 report submitted by them. 51 and 52. The entire report says they have not taken any step for taking possession.
What is it stated?
Regarding report, in report their possession they have not discussed anything.
Give us a paragraph where position has not been taken.
But they have not discussed about the possession.
That is different from saying we have not taken position.
Well, it is humbly submitted that on perusal of the BR case and such, their predecessor of interest of the applicant, namely Govardhan since deceased was an intermediary. It is submitted that once notification was issued under Section 4 and got published under Section all the lands held by the intermediary stood vested to the state. After such vesting, the intermediaries were only left out the right to detention, etc. Next, Lordship will get the next paragraph. The non-obstant of the Section 6 yellow, the last paragraph, the predecessor of interest of the applicant held prescribed ceiling surplus land had not exercised the choice under the land subsection 1 of the Section 6. So within the prescribed period, as a result, the said proceeding was initiated and the revenue officer has given to submit the form and the statement of choice. The retention of the land intermediary, it is also the recorded the predecessor of interest of the applicant exercise the option.
You know, exception have you stated? No position taken?
Yes, my lord.
Where?
Exception, my lord, I have.
Exception we have seen. Where is the not taking position stated?
But in main OA application, my lord, I have stated.
Acha, where is that? Are in peaceful position.
Yes.
Any opposition to that filed in the?
No, nothing.
Before
Nothing.
the tribunal?
Before tribunal, they have not used to any opposition.
No, there was just a direction for filing Milord report and that was disposed of, Lordship. And Lordship may kindly take note of page 52, Milord, BLRO's report, second paragraph, page 52.
Yes.
He says something, it is humbly submitted as such the said proceeding finally disposed of and well settled long ago in the year 1972. And Milord choice of
that well settled is as per the choice of retention of land exercised then.
And it says me review in the say bio exchange.
That is because the revenue officer allowed.
Kindly appreciate one thing where he's
no 1917 they give a reason in the previous paragraph.
Yes,
allowed.
Lordship.
Asked for amendment that was allowed in 1979.
79 completed.
So till 79 at least no position. Then you have not stated anything. There is no denial to this. Sorry to you, not it. The present challenge has been preferred against an order of the tribunal whereby the learned tribunal dismissed the original application filed by the writ petitioners. Full stop. The original application arose from the inaction on the part of the BL and LRO to dispose of an application of the applicants for the purpose of exchange of land in respect of the option of retention given by the predecessor in interest of the petitioners in respect of a vesting under Section 6 of the West Bengal Estates Acquisition Act 1953. Full stop. Next para. In brief, comma, the predecessor in interest of the writ petitioners, comma, the original intermediary, comma, had filed a B form, comma, thereby disclosing his options of retention of land from the purview of vesting under Section 4 of the 1953 Act. Full stop. Next para. Thereafter, comma, an amendment was sought to the said choice of lands sought to be vested, sought to be retained, comma, which was permitted in the year 1979 by the respondent authorities. Full stop. Thereafter, comma, the present appellants, comma, the successors in interest of the original intermediaries, comma, the present appellants of present writ petitioners. The successors in interest of the original intermediary, comma, again again made a representation before the concerned BL and LRO, stating therein that by mistake, comma, the Bastu, that is the dwelling house of the writ petitioners, was permitted to be vested, but by not including the said property within the list of properties sought to be retained in the Form B. Fullstop, thus, comma, the writ petitioners sought to retain the said Bastu property instead of the properties which had originally been offered to be retained. Fullstop, next para, the learned tribunal dismissed the challenge, comma, primarily on the ground that the predecessor in interest of the writ petitioners had already exercised such option. Fullstop, next para, learned counsel appearing for the writ petitioners cites such and such reported at 2000 নামগুলো দিয়ে দেবে, reported at 2003 9 SCC 253 for the proposition that there cannot be any merit in an objection based on laches and delay in respect of retention. Full stop. It was held by the Honorable Supreme Court that the authorities of the state had not lawfully and factually dispossessed the petitioners therein, who were the heirs of the intermediary, comma, of the khas possession of the lands in question. Full stop. The right to vindicate and protect their interest in the lands in question in terms of the enabling provisions of the 1953 Act, comma, it was held, comma, would enure, E-N-U-R-E, till they are dispossessed in the manner envisaged and by observing the formalities contemplated under the statutory provisions. For the next para, learned senior government advocate controverts the allegations and submits that an application, comma, practically seeking an exchange of the properties originally retained, comma, that too by the heirs of the original intermediary, comma, after a prolonged delay, ought not to be entertained. Full stop. Next para, learned counsel cites Kritibas নামটা দিয়ে দিও, reported at 1984 1 CLJ page 161, comma, a judgment passed by a learned single judge of this court in support of such contention. Full stop. Next para, learned senior government advocate next cites Omuk versus Omuk, reported at 1997 5 SCC 317 as well as 2001 5 SCC 664, comma, for the proposition that the vesting is complete upon publication of notification under section 4 within bracket 1 of the 1953 Act. Full stop. It is submitted that thereafter, comma, the heirs of the original intermediary cannot, comma, at any point of time, comma, seek an amendment to the original properties sought to be retained. Full stop. Learned senior government advocate next cites such and such, comma, where a full bench of this court, reported at 2017 4 CHN 190, comma, where a full bench of this court had held that a post-vesting transferee cannot come within the ambit of the expression intermediary. Full stop. Learned counsel cites an unreported judgment of this court in the matter of in WPLRT 48 of 2011 in support of the contention that once an option for retention had been given, comma, the heirs of the original intermediary cannot come after a prolonged delay, comma, in the said case 17 years, comma, seeking an interchange of the vested land. Full stop. Next para. However, comma, we are unable to agree with the contention of the learned senior government advocate. Full stop. Next para. Although the propositions as laid down in Arun Kumar Basu Supra and Tandon Brothers Supra to the effect, Arun Kumar Basu Supra and Tandon Brothers Supra as well as in Rajbala Barik, comma, to the extent that vesting happens as soon as a notification under section 4 within bracket 1 of the 1953 Act is published, comma, the Supreme Court, comma, in Shulekha Pal, comma, by considering the then pre-existing judgments governing the field, comma, came to the conclusion that the right of retention was not curtailed before khas possession of the lands in question was taken, comma, under section 10 within bracket 2 of the 1953 Act. Full stop. As such, comma, the position of law as laid down in Shulekha Pal Supra, comma, is that despite the land having vested under section 4, vested with in the state with the publication of the notification under section 4 of the 1953 Act, comma, the right of retention remains with the intermediary and his heirs till khas possession of the vested lands are taken by the state. Full stop. Next para. Insofar as Rajbala Barik Supra is concerned, comma, the full bench was dealing with a post vesting transferee, comma, who was held not to come within the ambit of the expression intermediary. Full stop. The logic was that the right of retention arises simultaneously with the vesting and can be exercised immediately thereafter. Full stop. However, comma, a transferee after the event of vesting cannot claim such right. Full stop. Such proposition, comma, as such is not applicable in the present case, since the writ petitioners are the heirs of the original intermediary. Full stop. The propositions laid down in Arun Kumar Basu and Tandon Brothers are without any doubt. Full stop. However, comma, as held above, comma, for the specific purpose of retention, comma, Sulekha Pal laid down that there is some dilution in the concept of vesting insofar as the intermediary and his heirs are concerned. Full stop. In WP LRT 48 of 2011, comma, the coordinate bench proceeded on the premise that there was no mistake or omission which could have prompted an amendment of the list of originally retained lands. Full stop. However, comma, in the present case, comma, the writ petitioners have made a representation on the specific ground that by mistake their Bastu land was wrongly omitted from the list of retained properties. Full stop. Next para. In consonance with the view taken in Shulekha Supra, comma, we are of the opinion that not only the intermediary but his heirs are entitled to retain the lands of their choice. Full stop. Such choice remains till possession is taken of the vested property under section 10 within bracket 2 of the 1953 Act, comma, although notionally the vesting occurs with the publication of the notification under section 4 within bracket 1. Full stop. Next para. In the present case, comma, even the respondent authorities have allowed a previous amendment in the year 1979, comma, thereby conceding to such proposition of law. Full stop. Next para. In view of the above, comma, we are of the opinion that the learned tribunal acted without jurisdiction in dismissing the application of the writ petitioners for changing their option in respect of the lands to be retained by them on the ground that the predecessor in interest of the petitioners had already exercised such option. Full stop. Accordingly, WP LRT 142 of 2025 is allowed on contest, comma, thereby setting aside the judgment dated January 27, 2025, passed by the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA number 4151 of 2022, and permitting the writ petitioners to file the B form with the fresh option seeking to retain their Bastu land. Full stop. The concerned BLLRO, that is respondent number 3, is directed to accept the fresh amended B form submitted by the writ petitioners, accept the representation of the writ petitioners, comma, as annexed at page 48 of the present application, comma, by treating the same to be না sorry, এটা কেটে দাও, এই সেন্টেন্সটা কেটে দাও। Leave is granted to the writ petitioners to file a proper B form, comma, in terms of their representation as annexed at page 48 of the writ petition, full stop. If so filed within a fortnight from date, comma, respondent number 3 shall consider the same and accept the same as a valid amendment of the B form originally submitted by the predecessor in interest of the writ petitioners.
B
E
form
form will not be available, Lordship.
Oh,
48 may be considered. Page 48. B form.
তাহলে একটা
form
কাজ
will
করে
not-
দাও, কনসিডার দ্য রিপ্রেজেন্টেশন দ্য বিএলআর শ্যাল, কি বললাম, accept the representation of the writ petitioners as annexed at page 48 of the writ petition as a valid amendment of the B form submitted. Accept the representation as a valid. করে দাও, আমি correct করে দেবো। Thank you.
Great.
We have a different bench. A different bench.
I have matter that Mr. Ghosh is there.
We don't have time. We have a different
No,
bench. We have to go to the other building at 3.
I thought it.